matter not before your lordship's court matter, bail matter. Below serial matters have been listed.
Bail matter, no?
Tied up matter, my lord.
You are mentioning a single case matter.
Yes.
That will not come down. Now the bench, as per the decision of
Roster bench.
don't mention, yes.
I will lordship may allow next week.
How can I? Please go through the that decision now. It will come before the roster bench. Any tied up matter that is not now applicable. Yes.
What is the compensation, land compensation? Government Act.
Give it.
Land acquisition matter.
Maybe taken
Yes.
on Monday.
Give it. Give it.
Land acquisition matter.
Please give it.
Obviously.
Yes, sir.
Supplement the list. Item number 1. Order dated 5/2/25. I have filed an complaint of affidavit and sufficient petition. They are not in record.
What affidavit?
Complaints of affidavit 17/2/20 passed by Honorable Court with writ petition.
For substitution of petitioner number 2.
My lordship, so it will be I number 3496.
That has not come.
Not-
When have you filed?
25/2/25.
Oh.
No, that is one thing. Another thing that when the matter was taken off on 17/2/2020
My lord.
before another division bench,
My lord.
you made a submission that that is also the pleading in the writ petition
My lord.
that you have constructed that hotel
My lord. Permission.
with permission from Puri Konark Development Authority.
My lord.
So that was your submission. So this
my
court passed the order that you are to produce the copy of the permission obtained from the authority.
My lord. Already I have filed 25/2/25. Already filed
25/2/2025. You have filed that permission. And also this.
Submission.
Have you served a copy on the State Council?
Government copy we already served on dated.
All right, it will come next week with those documents. You examine whether this writ petition is maintainable or not, because it is a order passed by the OEA collector from Tahsildar Puri. The notice was issued, as it seems, under Annexure 5, under Section 6(7), and in that claim case was instituted. Come to Annexure 5.
Notice number 43.
43.
Yes.
This notice was challenged, has been challenged also here, apart from the that Annexure 8, which is the order passed. Earlier, the petitioner approached this court and the matter was asked that he go and approach that authority. Now, against the OEA collector come Tahsildar order, I think the appeal is there. Just examine that. So if he has got the alternative remedy, as it appears even in the paragraph number 9 also, come to that paragraph number 9. This claim case was instituted by the administrator of Jagannath Temple, okay, on an application under Section 6(7)(a). So before the Tahsildar Puri, and against that order of the Tahsildar so it was moved before the additional district magistrate Puri in OEA appeal number.
Yes.
So because the appeal was maintainable against the order of so, in this appeal, the matter was again remanded to the Tahsildar.
Right.
And against that order, the writ petition has been filed. So the appeal provision is there.
Yeah.
So what you also take down and satisfy us.
Okay.
See your paragraph number 9.
Right.
Okay. Earlier in the OEA, the very same OEA claim case 34 of 90, when the order was passed, that was dismissed, and OEA appeal was preferred by the temple administration. In that appeal, the matter was remanded. You have mentioned in that paragraph number 9.
Right.
So now, after remand, this present impugned order has been passed. So if that has been passed, you are to challenge it in the appeal. Why have you come in the writ petition? You are to satisfy us.
My lord, next week I will satisfy this provision.
So get down that the learned counsel for the petitioners submit that in pursuance of the order dated 17/2/2020, he has filed the permission obtained by the petitioners from Puri Konark Development Authority for construction of that hotel, Hotel Srimurti, for construction of the hotel. You have filed that permission with what?
Permission out here. Annexer.
No, se permission ta kemti file karte goda memory file
Like
karte
counter with affidavit, counter
Acha, with
affidavit
an
with annexer.
with an affidavit, and he has also filed
I number.
somebody died. You said
No, my lord. OP number 2. Yes, sir.
OP number
Petition
number 2
my
died,
lord.
and she has also filed substitution application for petitioner number 2, Narayan Saw, who has died, and that has been registered as IA number
I number 3496 of 225.
3496 of 2025. Stop. Copy of the interim application has also been served on the Learned Council for the state. Put up this matter next week along with the IA number for substitution. So also the affidavit which has been filed along with the permission. Permission later. Okay.
Obligement.
Date they will make it on 5th of March 2025.
Item 2.
Am I present? In the case, the original petitioner was placed under this initial proceeding against him in the 1996.
No, you have challenged the order of the
Single judge.
single judge. You
That
come to that.
Annexure 3. I was retired from 2006. Proceeding initiated in 96. Proceeding continued 2014 to continued. I approached my lord in 2020 for passing of the proceeding. And my lord directed to close the proceeding final within 1 month. They are not complied. In the meantime, retired. So after retirement, punishment was issued by the authority, by the DEO, because no authority at all. As for pension rule, it is only the government they can impose the punishment.
No. What order has been passed by the honorable single judge?
Annexure 3 1998, madam.
Yes, sir.
They are directed to file appeal.
Yes. So
Even there is no provision under the pension rule for filing appeal.
Yeah.
Under the pension rule, 1992 pension rule, there is no provision.
You have challenged. Your order was the proceeding was initiated under Rule 15 or not?
Initial for 1996. After superannuation, if
if the proceeding was initiated
My lord.
under Rule 15 of
15.
the so and so,
My lord.
then the appeal lies in the final order was passed in that disciplinary proceeding against
Final
you.
order is to be passed after superannuation. Proceeding is converted to Rule 7. After retirement, an employee, the proceeding under Rule 15
Let
is.
us see that.
Yes, but that's the intercase.
By virtue of Rule 7 of the
Yes.
Orissa Civil Service Pension Rules, the proceedings under CCA rules only continues.
Continue.
So order is passed and the CCA
No,
rules read with this.
that one kindly see para Rule 7, para 2. Rule 7(2).
It only continues. That's
Continue, but they can issue final order. That is my intercase.
Which provision you are referring
Rule
to?
7(2).
Rule 7 of?
Pension, OCS pension 992.
Yes. That will be.
7(2)A. Rule 7(2)A.
Rule 7(2)A of
OCS pension 992.
OCS pension.
My lord.
Rules.
My lord. Rules 992.
1992.
My lord.
Hmm.
7(2)A.
Yes.
Now got it. Such departmental proceeding refer to sub-rule 1, that is 7(1). If issued with the while government servant was in service, whether he before his retirement or during his re-employment, shall after final retirement of the government servant be deemed a proceeding under this rule, under this rule, 92 rules, and shall be continued or concluded by the authority by which they were commenced in the same manner as if the government servant had continued in service. Proviso. Provided that when government proceeding is instituted by an authority subordinate to government, that authority shall submit a report before the finding to the government. So they are the authority to pass final order.
No, it's not. It's not. It's a proceeding instituted against you under 1962 rules.
Yes.
Yes. In that rule, this order was passed.
Yes.
So that is passed under Rule 15 of the.
That is my intercase, my lord. After retirement, the rule is depends. That.
Ajib is continuing.
Yes.
Ajib was deemed as 60%.
After converted, so pension rule. A pension rule only the government, the authority, they can only submit the report to government, the final report.
CCA rules 1962. What order was passed against you?
Recovery of the entire amount. Even I have no connected to that case. And in the meantime, that man expired. And the substitution allowed by the doctors. So legal yes.
So here in this writ petition, you are challenging annexure.
Yes,
In the writ petition, you challenged annexure 1.
No.
That is the order dated 3/5/2021.
Yes, madam. Annexure, entire annexure 2 page.
ठीक से कौन दो?
Yes,
अपना writ petition ने कौन challenge करते ले?
Punishment में final punishment of that is our serial page number. Annexure 18. Annexure 18 to
3/6/2021. Annexure 18.
Annexure 18.
Okay. Where is that order? Annexure 18.
That I have something. And that is page 81.
81. What order was passed there?
Please
place that order.
That's page 82. Operating parties. An amount of rupees also shall be confirmed as misapplied government money when the involvement of the delegate officer has been established. However, an amount of so and so have been out of which delegate has officer submitted an undertaking dated so and so to refund the amount which are recovered from gratuity amount and deposited in the treasury. The delegate officer directed to deposit the rest of the amount. And that was under challenge. On the ground that after 20 years the order has been passed. 96%.
You are to satisfy.
Yes, ma'am.
We are not on other point.
Yes, ma'am.
Because the learned single judge has not adjudicated.
Yes, on merit. Yes, ma'am.
Yeah.
My entire case is that after retirement, the department, the decision of proceeding.
You come to that page number 82, which you are placing, which you challenge before.
Yes, madam.
And see, in the last portion.
Madam. Yes, in now therefore, yes. The rule subclause 1B of subrule 2, yes. Rule 15 OCCC rule of the court of submit representation and he may. Yes, madam.
Read out.
The punishment, sorry, my punishment is page 90.
No, you come to read the last portion of page 80.
Page 82 is the second full notice.
Yes, now they are for?
Yes. Now they are for, madam.
Page 82.
Now therefore, in accordance with clause 1B1 B of subclause 10 of rule 15 OCC schedule and 63. See, how this called upon submitted the representation as and which as he may.
So this was passed under which provision?
Under the 92 rules.
1962.
Under the 62 rules.
Huh?
Under the 62 CCA rules.
Okay. 1962 rules से ये order टा pass हला. आपन को आला जे representation दवा. तापर आपन representation करने. Then what happened?
Next page 83. Final order passed page 90.
83 आपन representation दवा. Then what happened?
83 I specifically mentioned that the
whatever it may be, what final order was?
Final page 90.
Yes.
Page 90 kindly see.
Yes.
Last the punishment is page 91. 1. An amount of so and so.
The first para. First para.
Yes.
Para. 90. Page 90.
Yes. Whereas in accordance with whereas the disciplinary proceeding has been initiated under rule 15 of the 1992,
62.
Against Somnath Rao, ex-senior and in charge of accounts in the office of the school funds. Whereas Rao submitted the written or submitted defense, the name charges. Whereas Deepak Kumar Padi, block officer, by this inquiry officer conducted the inquiry. Whereas in accordance with rule 6, rule 1A, sub rule 2 of rule 15, the same inquiry report communicated to delegate officer by the order so and so restored court. Affording him an opportunity to submit representation within 15 days. As may wish to make in finding of the inquiry officer. But no representation received, I have submitted.
So after receiving your representation, this order was passed, final order. And this was obviously passed under the provisions of 1962 rule.
That is my entire challenge because of the signature. This order cannot be passed by the authority submitted to government.
So if cannot be passed, then appeal is like you can
appeal against the pension. There is no provision of appeal.
But this question of pension was
yes, because the rule says once I retire 96 and 6 to the pendency of the proceeding. I retire. Therefore,
As if, the word as if is there.
Yes.
Deeming provision.
That
As if you are continuing in the
Yes.
department.
they
So
will
that as if you are continuing in the department, that itself indicates that your case is considered under departmental proceeding under the provisions of
1962.
OCS CCA rules.
is entire
That's
case.
all.
After conclusion of the proceeding, they shall submit report to government. That is the rule 7 to be private pleasure.
And
They cannot
further this fortifies, whereas the Honorable High Court of Orissa and Cuttack wide order dated 30/3/2021 passed in WPC number 8772 of 2021 on the matter and directed to conclude the DP within 1 month. Otherwise, the disciplinary proceeding will be automatically passed. So
earlier I approved.
There is no
I am directed to close the proceeding 1 month. Proceeding.
What do you say, Mr. Nayak? Mr. Nayak, what do you say?
I will need examination. I need to examine.
And
Yes,
I need to examine further.
because the order which was passed, that is very clear that it was passed under the 1962 rules.
Man,
And the relevant rule is 15. And which rule? Rule 23 about the appeal provision?
appeal rule 23 under the CCA rules.
Yes.
But my entire case is that after superannuation, punishment can only be imposed under the after superannuation. There is no link between maximum servant relation. Therefore, consciously writing to rule says that punishment can only be imposed by government. The discipline authority after closure of the proceeding submit report to government and government shall take a final decision. And that too with consideration of OPSC. A specific mention on the pension rule. I am a retired person. Had I been continuous service, it should be applicable. And the rule, and by the rule, also 7(2)(b) clearly says, such department proceeding are therefore sub-rule 1, if not issued with the while the government servant, whether before his retirement during service, shall not be issued, shall be issued, shall not be issued, shall be sanction of government. So after retirement, the rule proceeding is to convert to pension rule, and the proceeding after closure, they shall submit report to government to take a decision. What the punishment they want.
Your paragraph 15 itself makes the paragraph 15 of the writ petition.
Yes.
If that is accepted, then entire purport of continuance of disciplinary proceeding will be rendered odious.
No.
You read it.
Paragraph
15. What you have submitted.
Paragraph
15 of the writ petition. If that is accepted, then under pension rules, no disciplinary proceeding can continue.
Yes.
So that's why Rule 7 becomes odious. That as if you are continuing, that goes.
What I submit after they shall finalize the proceeding and submit report to government will take a decision. That is entire case. Once I retire,
Have you approved the appellate authority?
That man expert.
No.
That man expert in the meantime. So no scope of any appeal officer in the meantime.
No,
Only to
legal
decide.
Legal error can, if you
No. The original petition approached. During pendency, he extra.
No, it's all right. Now, suppose we held that the appeal is maintainable. Now, this man who has been, ladies who have been substituted, they can prefer the appeal. You have not preferred the appeal in terms of the direction of the single judge.
They cannot prefer, madam, because they have no knowledge about the proceeding. They are not participating in proceeding. They cannot. That
Sure.
My lord, my lord.
This repetition was passed by the order dated 2096 into 21, passed by the land single judge in the location number 18173 of 2021. The order there, which was Department posting. It is changed in 1996. Also, the order by the judge. Order that is all the possible service and pension benefits in favor of the applicant in stipulated time. It appears from the income order dated 29/6/2021. Applicant is there after hearing the parties, current counsel for the parties and going to be across. And since both the parties admitted that the disciplinary authority, the district education officer,
My lord.
district education officer, on the basis of the proceeding initiated against the petitioner under Rule 15 of the OCS bracket ACC Act 1962, passed the improved order of punishment dated 3/5/2021. Therefore, the order is an appealable one. The contention was raised by the Planning Council for the petitioner during the hearing of the petition that after the retirement of the petitioner, OCS and CCP 1961 is not applicable. The current single judge has said that the question of jurisdiction will also be considered by the appellate authority. Accordingly, the petition was disposed of permitting the petitioner to approach the appellate authority, raising all questions that are raised in the petition before the appellate authority, which is to be considered in accordance with law. The Grand Counsel for the petition bring the attention of this court to ask for which you
The rule 7 to
but the ask to represent high representation.
depends on
Representation to
depends on the during proceeding, my lord. Yes, it will proceed. Under the
2021 passed by the district
education officer.
education officer. Wherein careful consideration of the charges vis-a-vis the statement of the defense and finding of the inquiry officer. The decision was taken to accept the finding of the inquiry officer. And punishment was proposed. In accordance with clause 1 bracket our bracket is clause B of Sahoo of rule 15 of OCS CPA 1962. The appellant was called upon to submit his representation against the proposed penalty. The Learned Counsel for the appellant submitted that the petitioner submitted his representation before the district education officer and the district education officer had order dated P5/2021 for the penalty on the appellant. Which was improved before the branching villages in WPC number 18173 of 2021. The petition of the Land Council for the petition is that in view of Rule 7 of the Orissa pension rules, after retirement of the appellant, after superannuation of the appellant, the proceedings should have been continued under the Orissa pension rules. And therefore, it is to be improved order to be deemed to have been passed under Orissa pension rules and not under 1962 rules. However, in
ये जो छोटे बच्चे में proviso
further submits that section rule 7.2 the proviso to rule 7.2a indicates that if the when the departmental proceedings are instituted by an authority subordinate to government, that authority shall submit a report recording its finding to the government. And
the government is the competent authority to pass final orders.
And the government is the final authority to take the decision. And the impugned order of punishment has been passed contrary to such provision under the Orissa pension rules. Land Council for the state seeks some time to examine the matter. We have to issue notice for issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the state accepts notice on behalf of all the opposite party, extra copy of the
How do you have
How do you have Accountant General पे अलग है नहीं all
Account General Mr. Patra will give. S.K. Patra.
1 to 3 state government.
Opposite party number 1 to 3, and so far as opposite party number 4 is concerned, who is to appear?
S.K. Patra.
SK Patra.
Sudhir
Sudhir Kumar
Patra.
Patra.
Normal appearing.
Sudhir Kumar Patra.
SK
Normally he usually he
Mr. Sudhir
appears.
Kumar Patra, who is to appear for the opposite party number 4. Copy be served on him within a week. Matter be listed 4 weeks after. Yes.
And some also pick a date, but in some case. And man, it may not add in the meantime. That is your.
So see, pattern examine कर दियो
सही बात है।
provision टा examine
ठीक है, ठीक है। I will not.
Item 3.
The state was to file counter. There's for some more time because
Your Lordship may see Annexure 7, page 39. The compensation amount is lying in deposit for disbursement since 2014, madam. Page 39. That has to be only released. Bureaucratic rectification, that is why it's pending. Page 39.
We have mentioned in the order dated 31/20/25 also.
Yes.
About that. Please come to that order. What a blessing. Very. Okay, John, to go.
Order copy.
No, order copy is with you. Say, welcome.
Mr. Yang Rudgata. Julia Rudgata.
Yes.
Kindly try to operate.
Twice कौन पाइजे? 31/2025
ଆପଣ try କରନ୍ତୁ ନିଜେ hand ନଦେଲେ ହବନି ଶିଖି ପାରିବେନି ଶିଖନ୍ତୁ
31/2025 ର order ଟା ବାହାର କରନ୍ତୁ
ବ୍ରହ୍ମ ବିଦ୍ୟା କିଛି ନାହିଁ ସେଥିରେ ଖାଲି ଫିଙ୍ଗର ଟଚ୍ ଦେଲେ ସେ ଚାଲିବ
ଆସିଗଲା please read it.
This matter is taken up through hybrid arrangement. The petitioner has filed the petition seeking for a direction to the opposite party to release the compensation amount with interest to the displaced families of Kanswal irrigation project belonging to village
Border
Nuagaon, Dungajor, Ranipia and Maldi in the district of Sundargarh in accordance with the law within the stipulated periods and with a further direction extend the benefit as per the rehabilitation policy which was formulated by the Government of Orissa, Department of Irrigation as per resolution dated 1990 under Annexure 1. The Lord and Council for the petitioner submit that the petitioner have filed representation from time to time and the last representation have been submitted to the Secretary to the Government Water Resource Department opposite party number 2 under Annexure 8 series. But no response has been received from the said opposite party and the petitioner have also not received any compensation. Government Council for State 6 times to obtain instruction in the matter, more specifically with regard to the status of the petitioner as to whether any order has been passed on the representation filed by the petitioner under Annexure 8 series. This matter.
Yes, Mr. Naik, what do you say?
I haven't received.
That is already deposited. It is to be released in favor. And for that, how much time you require? This is already passed on 31/2025. So tell us one more date we can give you.
2 weeks.
2 weeks. All right. Land Council for the State 6 for the 2 weeks time to obtain instruction as per order dated 31/2025. So release this matter. 17th ratio.
Okay.
All right.
Not to just indicate more specifically with regard to Annexure 7. That
why is the order detail is yes.
Obliged.
Item 4.
4 mailbox is an appeal by the state. May I pray to call this matter on Monday if it is convenient to my house?
Okay. As prayed for by the Land Council for the state, list this matter on 3rd of March 2025.
Item 5.
My lord, permitted to allow in VC, my lord.
Yes.
On behalf of Surya Narayan Sahu and demands of our mother-in-law, may kindly adjourn today.
No, we'll adjourn, but there are so many defects which you are to remove. And 7, 10, 11, 14, V and 20. Are you aware that which are these defects? What are these defects?
I'm the proxy counsel, my lord. On behalf of
Okay.
I'll just inform.
The mention is made. What is your good name?
Manoj Kumar Nayak.
Manoj Kumar Nayak. On behalf of Mr. Surya Narayan Sahu for adjournment on the ground that there is bereavement in the family. Put up this matter. Kebe chahuchandi?
My lord, maybe 1 week after.
Week after. Put up this matter 17th. 17 March. Yes.
Item 6.
Item 6, madam. Well, the petition has a small prayer matter. As the petitioners are the legal heir of Annexure 1. Annexure 1 was recorded in the name of our father, and that land has been acquired by the for Onuguru Duburi Sukina Road that has been acquired. Notification in the year 2010. And after receiving the compensation, this petitioner along with his mother, who has been died in the meantime, had a repentation for reconsider by the annexure number 3 member. But that was pending since 2018. I have a small pair, let the matter be refer as per the rule matter to the subject for reconsideration. Only my small pair, and not accordingly, by the annexure 4, this honorable court has passed similar order.
No, this is of 2018 matter.
18, land has been acquired by the notification 2010. These are the notification. Accordingly, we have been get the compensation of 2000 as per our check raja pilot 2008.
No, we are not on that. What is the LM case number?
LM case number 51 of 2010.
Where have you mentioned?
More petitioner achi. Annexure 3 page 12.
No. You see in the annexure 3, what is this LM case number? Upper dekhontu. Case number is 51 of 2010.
That was still pending. No action has been taken till 2018.
Similar matter भी से dash ही
similar matter भी से आई था.
page 17 में दिखते हैं.
That was still pending before the law.
I think so.
Put a direction.
Para 3 दिखंतु. Para 3 is on the dash.
It should have been registered as well. 2018 ne upon file करचंती. Is it your case that it has not yet been registered?
No,
we will call for a report why it has not been registered.
This is I have annexed my office copy, but I have office copy of annexed.
He has to obtain the instruction.
In fact, my lord's order is already there at page 17.
Who is dead?
My lord's order is already there in a previous petition, 23255 of 2023.
No, my brother was a party to that order. He has pointed out that in there also this
case number is dash, but arising out of LA number is correct.
Same project.
Question is that
but by now miscase number ought to have been assigned.
So, I may suggest one day, if not, I may
you get the number. You can get the number.
No question. Let us the environment. Mr. Rajesh Kumar Apatro, Senior Panel Counsel, Union of India, appears for opposite party number 4 by filing the memo of appearance, which is taken on record. The name of the land council be reflected in the cause list henceforth. Stop. This writ petition has been filed by the petitioners so and so with a prayer for a direction to refer annexure 3 to the appropriate court under section 18 of the LA Act for determination of the higher compensation amount in accordance with law. Land counsel for the petitioner has referred to the application which has been annexed to this writ petition as annexure 3, and it has been mentioned that it is LA miss case number ... of 2018, which arises out of LA case number 51 of 2010. When I made a query to the Land Council for the petitioner as to why the LA miss case number has not been reflected in annexure 3, he submits that till date no LA miss case. The LA miss case has not yet been registered. Let the Land Council for the state obtain instruction regarding the registration of LMS case number ... of 2018. What time you require?
17th.
Put up this matter in the week commencing from 17th of March 2025. Free copy of the order be handed over to the Land Council for the state.
Okay. Petition may kindly serve.
Let a copy of the writ petition be served on
in course of the day.
in course of the day. Yes. Name the bill which is reflected in the cause bill. Yes.
Item 7.
From the section, you'll type from next week, you'll see.
What is your prayer?
Prayer, you'll also I have challenge annexure 12, also 8, 9, 10, you'll see. That is
Annexure 12 you are challenging.
my lord.
The order passed by the RDC in OGLS appeal
My lord.
number 2 of 2022.
Lordship. Here initially
OGLS appeal OGLS Act.
initially the land
Wait. 71C. Yes, what is the illegality in this order?
Actual Lordship, they are saying that I was not used as the purpose I was allotted, but that is not correct. Due to Corona at that period, while they were visit field inquiry at that time due to Corona, and also due to my health condition, since 2018, I was not use any agriculture there. But prior to that, since from the date of allotted me, I was using the land. In my stoppage also, answer 7. Stoppage reply.
So the lease which was granted in favor of the petitioner or the appellant in that OJLS case, that was for a particular purpose.
Yes.
That is for agriculture purpose. But you did not carry out the agricultural operation.
No,
rather you sold the land to somebody else.
No, I have not sold.
It has been mentioned here.
No.
Subsequently, the lessee took steps to sell the land, alleging financial constraint, and when the same was refused, you approached this court, and this court directed the sub-register to examine. So there was an attempt at that point of time. Then the field inquiry was made, and even though 15 years have passed in the meantime, since the date of taking the lease, it was not used for agricultural purpose. That is the reason why the resumption proceeding that was it was resumed and government.
That point is wrong, Your Lordship. Since 2018, as I was suffering cardiac problem since 2018, thereafter I
no, when the lease was taken, what is the lease was taken on 7 to 2005. So 7 to 2005 pare field inquiry hela kebe after 15 years.
My lord.
So by that time also no agriculture. Gote Moram road ta bhitar jais.
That is government road. Side road.
So when the lease was granted for a particular purpose, and the condition of the lease is that if you do not utilize for that purpose, then the resumption proceeding, what is wrong in it?
No, Your Lordship, since 2018, I have not used agriculture purpose because
how could this Moram road come?
That is existing government road, Your Lordship.
आपण परा एग्रीकल्चर आपण को गोटे जमी दिया एग्रीकल्चर करिया पई आपण जमी किछि कले नाही एग्रीकल्चर पई सेठी गोटे मोरम रोड नै छथि सेथि पई से माने कहउछन्ति जे that is the order that it is in contravention of the provision of that lease deed, and that is how they have adopted this resumption procedure.
And what is stated is has constructed, you have constructed a Muram road over the plot without permission, which indicates the intention to use the land for non-agricultural purpose. When you are saying that it is government road, it is not government road. You should have objected to when they were laying the road.
No, prior to allotted me.
That means
prior to allotted me the land, that road is existing.
Prior to 2018? 2005?
My lord.
How can this be? And you have accepted this?
With my lord's permission, may I invite my lord's attention to page
apart from that,
so for agricultural purpose, when a plot is allotted to you,
my lord,
so that itself presupposes that the entire patch of land is itself an agricultural land without any road on that.
No,
had there been any road, you could have objected to.
That is side of my.
They are saying that you have constructed this after 2005.
No, yeah.
That is what is reflected in the finding of fact.
Finding also that is page 48, which is
maybe taken up next week. I will satisfy. Apart from that, there is this one also, your lordship. If not used any other purpose,
please wait.
Except the purpose.
48 was your comments portion.
My lord, sir, considered the show cause reply in detail, and pursuant to that, after that, he has given his comments on each of the points raised in the show cause reply.
Mr. Dwivedi himself was present on the date of field visit to the leasehold property on 21/12/2021 along with Tahsildar Baripada, Revenue Supervisor Baripada and RI B. Kamari. He himself admitted that land is lying vacant since the time of the lease. To affirm this, he has also put his signature on the field visit memorandum admitting fact that the land is not cultivated since last 15 years in presence of the above aforesaid official. So the claim of doing cultivation from the year 2005 to 2018 is a false one and against the earlier order of admission of fact, so on so. Hence, the written reply is not valid one and against the finding made during the field visit. So this is the finding. The officials visited and during that field visit also you said that no such agricultural operation has been done. It is lying as such.
এটা ভুল লেখা হয়েছে বলি কি এটা ভুল লেখা হয়েছে ফ্যাক্ট ফাইন্ডিংটা এটা ফিল্ড ভিজিট রিপোর্টটা ভুল ଅଛି ବୋଲି କୋଉଠି ଆପଣ ଜଷ୍ଟିଫାଇ କଲେ
ରିପ୍ଲାଇ ରେ ମୁଁ ଦେଇଛି ପେଜ 37 ଇୟର ଅଛି
yeah against after page 48 this comment which my brother has read to you just now, this portion where you have admitted this part of admission is wrongly reflected in the comment portion. Where have you taken this objection before the competent authority?
Pursuant to the Annexure 6 college.
तहसीलदार बारिपदार से ऑर्डर जो आपने प्लेस करा
will taken up next week. I will satisfy.
पूरा satisfy ही छिड़ा है ना ଗୋଟେ ଗୋଟେ ପ୍ରଶ୍ନର satisfaction ପାଇଁ ଗୋଟେ ଗୋଟେ ଡେଟ୍ ନେଇକି କରିବେ କୋଉଠି ଏଇ ଯୋଉ ରିପ୍ଲାଇଟା ଦେଇଛନ୍ତି
ଆପଣ ଏଇ ଯୋଉ
35 ରେ
ତହସିଲଦାରଙ୍କର ଏଇ ଯୋଉ ଯୋଉଟା ଆମେ ପଢିଲୁ ବର୍ତ୍ତମାନ ତା ଏଗେନ୍ଷ୍ଟ ରେ ଆପଣ କଣ କଲେ ତହସିଲଦାର ବାରିପଦା ଅର୍ଡର ଏଗେନ୍ଷ୍ଟ ରେ ଯୋଉ ପାସ୍ ହେଲା ଯୋଉଟା ପେଜ 41 ରେ ଅଛି against that order where have you approached?
Went to the collector my lord at page 52 to confirm this order of the
52.
That is their internal communication. Tahsildar, thereafter sub-collector, thereafter collector.
সেটা আপনার নলেজ রে ଥିଲା ତ ସେ କମେଣ୍ଟଟା ଯଦି ଆପଣଙ୍କ ନଲେଜ ରେ ଥିଲା ଆପଣଙ୍କ ନୋଟିସ ରେ ଥିଲା ସେଇ ଫାଇଣ୍ଡିଂ ଅଫ ଫ୍ୟାକ୍ଟ ଅନ୍ ଫିଲ୍ଡ ଭିଜିଟ ଇଜ ରଙ୍ଗ ବୋଲିକିରି ଆପଣ କୋଉଠି କହିଲେ କାହାକୁ
ନାଇଁ,
କହିଲେ କୋଉ
challenging
competent
that
authority ପାଖରେ କହିଲେ
challenging that I was approached this honorable court and this
ସେଟା କାହିଁ
honorable court
ସେଟା କାହିଁ ସେ ପାର୍ଟଟା କାହିଁ କୋଉ ଜାଗା ଅଛି ପିଟିସନ କାହିଁ
Where is your petition in the OGLS appeal memo? The OGLS appeal ରେ ସେ ground ନେଇଛନ୍ତି ଯୋଉ ମୁଁ spot ବି
ଫାଇଣ୍ଡିଂ ଟା ହଁ appeal ତ
I
ଫାଇଣ୍ଡିଂ
have
ଚ୍ୟାଲେଞ୍ଜ କରିବେ ନା
I have not
ଆଉ
annexed
report
your
ତ
lordship.
ନୁହଁ
Maybe taken up next week in additional
because
affidavit. I
whatever
will
you
file.
are stating that ସେଇଟା ମୋ presence ରେ ନଥିଲା ମୋର ଦସ୍ତଖତ ନେଇଗଲେ ଏମିତି ସେ ଅଫିସର ମାନେ କେହି ଆସିନାହାନ୍ତି ଯଦି ଏଇଟା ଆପଣଙ୍କର କେସ୍ ଅଛି ତାହେଲେ ଆପଣଙ୍କର ଅପିଲ ଗ୍ରାଉଣ୍ଡ ରେ ସେଟା ନବା କଥା
File
ବୁଝିଲ
by next week your lordship.
ଯୋଉ ଅର୍ଡରଟାକୁ
Additional
ଚ୍ୟାଲେଞ୍ଜ
affidavit.
କରିଛନ୍ତି ଯଦି OGLS appeal ରେ ସେ ଗ୍ରାଉଣ୍ଡ ହିଁ ନାହିଁ first time how can you take that ground in the writ petition?
even
OG
page number 53 is also against you page number 53 ଦେଖୁନାହାନ୍ତି resumption ଯୋଉ orderଟା ହେଲା ସେଥିରେ ପ୍ରଥମ second paragraph ଟା ତ clearly ସେଟାକୁ reflect କରିଦେଲେ in the meantime it is ascertained from the report of the Tahsildar Baripada that Sri so
is there
has
any
not
doubt
used
that
the land
suppose a lease is granted to you for a particular purpose, lease of the land, and you do not utilize for that purpose, whether the government can initiate a resumption proceeding or not?
No, your lordship. There is a decision
3B ଟା ପୁରା ଅଛି section 3B
decision of Supreme Court, your lordship. If not use any other purpose and line.
Sir, ଆମର ସେ ନରୋତ୍ତମ ରଥ କେସ୍ ଆମେ କଲୁ ପୁରା ମୁଁ I was party to that ନରୋତ୍ତମ ରଥ କେସ୍ ରେ ଏଇ ଯୋଉ ଭୁବନେଶ୍ୱର ସବୁ ପ୍ଲଟ ଉପରେ ଆମେ କଲୁ ସେଥିରେ କଣ କହିଲୁ ଲାଷ୍ଟ ପୋର୍ସନ ଟା ପଢିନାହାନ୍ତି କି if you have occasion to take action you are free to take action under section 3B you can proceed not under another section so sir, that holds the field now ଆପଣ ବର୍ତ୍ତମାନ କହିପାରିବେନି ଯେ ହବନି that judgment is never challenged the judgment the state has accepted and you have also accepted
so merely saying no is no answer, right? So they have the authority and they have initiated the proceeding and ultimately found that
It was challenged
and it was demanded back.
Norottama Ratha set aside.
Not on the proposition, your lordship is
set aside that each
that proposition
be individually.
now it is to be individually hard. That is the order. Today general order କରିକି
this bench is leading.
Then I stand corrected. I stand corrected.
But this proposition is still there.
No, I did not. I did not.
So you want it next week?
ତାକୁ follow କରିକି ଗୁଡ଼ାଏ decision ବି ଆମେ
all the cases have been set aside in that case. And individually it is to be hard.
କାରଣ ମୁଁ ଗୋଟେ individual case ଟା କରିଥିଲି justice
as prayed for by the land council for the petition. Next week man 3 तारीख proposed 3/3/2025. Yes.
ଦେଖନ୍ତୁ ଆପଣ ପ୍ରପର ରେକର୍ଡ ଆଣନ୍ତୁ, ଦେଖନ୍ତୁ କୋଉଠି ଆପଣ ସେ ଫାଇଣ୍ଡିଂ ଅଫ ଫ୍ୟାକ୍ଟ, କାରଣ ଫାଇଣ୍ଡିଂ ଅଫ ଫ୍ୟାକ୍ଟ ଆପଣ ଅପିଲରେ ଚ୍ୟାଲେଞ୍ଜ କରିବେ କି ଅଥରିଟିଙ୍କ ପାଖରେ ଚ୍ୟାଲେଞ୍ଜ କରିବେ। ରିଟ୍ କୋର୍ଟରେ ଫାଇଣ୍ଡିଂ ଅଫ ଫ୍ୟାକ୍ଟ ପଶିବାଟା ବହୁତ ରେୟାରିଟି, unless there is a grave or glaring।
ଇଏ ଯଦି କହୁଛନ୍ତି ଯେ ଆମ ପ୍ରେଜେନ୍ସ ରେ ଆପଣ ଉପସ୍ଥିତ ଥିଲେ, ନିଜେ କହିଲେ ଯେ ମୁଁ ଏଠି ଜମି ଚାଷ କରୁନି, ତାଙ୍କର ରିପୋର୍ଟ ରେ ଦସ୍ତଖତ କରୁଛନ୍ତି, you cannot deny the same in a writ court because it would be disputed question of fact. First of all, whether you have taken the ground, sir, the noting which has been mentioned there, that is wrong. I was not present, my signature was taken forcibly, whatever it may be. से ग्राउंड जदि आपनकर ओजीएलएस अपील रे नै नांती ताकू फर्स्ट टाइम एठी नउचंती जे ना आज्ञा मु सेमती चाष करूथिली, सेमती आसी गोटा मोठू नै गले, मु दस्तखत का नै, एई सब जिंस रीट कोर्ट केमती डिसाइड करे।
सेटा सेल्स टैक्स रे बहुत हुए। से जो रिक्शा वाला नै कि जानती बिछणा, से सेमती गोटा हेइता, से बिछणा सेंटर से गोटा का से कला मु अमका दुकान को नै कि देबी, है से गोटा कहि दितला, तार स्टेटमेंट को रिकॉर्ड करी करी से ता ऊपर असेसमेंट हे गेला जे नै परचेजर हैज नॉट पेड द टैक्स। केमती हुए से गोटा आ सेठी कहिथिबे जे आपण से कोन लिखि देथियो, कहे 10 कर से 10 कर दिछियो कोन, दिस हैपेंस। କିନ୍ତୁ ସେଟା ଚ୍ୟାଲେଞ୍ଜ କରିଥିବା ଦରକାର, ସେ ଫ୍ୟାକ୍ଟ ଫାଇଣ୍ଡିଂ କୋଟା ଦେଇଥିବା।
नेक्स्ट केस
Item number 8.
ଏଇତ ଅନବ୍ୟାପ ମିଳିତରେ ଏସ୍ପି ରଥ କାଲି ଆର୍ଜେଣ୍ଟକୁ ନେଇ
नेक्स्ट
Item 9.
My lord, item 9, 10, 11, 12, 13, adjourn to 1 week after.
अर्जुन टू
1 week after.
what is
ଆପଣ କମେଣ୍ଟ କଲେଣି ଆମକୁ?
what
ହୁଁ?
what is your good name, madam?
Gayatri Das.
Huh?
Gayatri Das.
Gayatri Das. So that is not the way to make a submission. Just change it, just modulate it, okay?
ଶିଖାନ୍ତୁ ମିଷ୍ଟର ରଣଜିତ, ବସିକି ହସିଲେ ହବନି।
That there is some
you have to educate the young counsel.
some difficulty is there. My senior is not ready or he has some, so matter may be kindly in this way submission is right.
ଆପଣ ସିଧା ଭୁଜ କୁ ପଳେଇଲେ, ଖା ଗିଡ ଭୁଜ ତିନିଟା ଅଛି ନା।
Yes, so
Just to mention, Lordship may adjourn, but here the applications that the petitioners have filed, petitioners have not filed the applications. That
no, his senior is not
yes,
there.
just
if any adverse order is passed, the senior will ask him why.
Yes.
So we are just taking up next week.
Mahanadi Coalfield?
No, state.
Mahanadi Coalfield is main contender.
Prayer is against us.
Acha.
As prayed for by Ms. Gayatri Das, this is matter next week. Okay, 15 तारीख next.
13.
Item 14.
I need pattern number 3. 4 को
4 तारीख, okay. क्या आगोटा 4 ही कर दूँ. 4/3/2020. ये जो उठा आउट है किसी ना आइटम नंबर तंकर 7 तारीख से तो 4 कर दूँ. 4/3/2020. Yes.
My lord, in this case, last time Mr. Government Advocate raised a pertinent question that the writ petition is not maintainable against the confirming judgment, my lord. I have cited 2 decisions, my lord. Lordship may see 2 decisions where, my lord, Apex Court confirmed that the writ petition is maintainable.
No, you are challenging which order?
My lord, against the confirming order passed by the reference court, my lord, without issuing any notice.
Just come to that order.
My lord.
Annexure 2 is that order.
My lord.
Page number 14. All right.
My
Please place it.
My lord. Neither the petitioner nor his counsel is present today. No step is taken on his behalf. Either the present land acquisition case is instituted basing upon reference application under Section 18 of the Land Acquisition Act by the petitioner and subsequently submitted to this court by L.A. Jagatsinghpur. This is a reference applied in the year 2004. Originally, this is a land acquisition case of the year 2002. Since then, till date, more than 18 years have been elapsed. The Honorable High Court is pressing hard to dispose of the year-old cases. On the other hand, the petitioner in this matter is not present in the court. No steps has also been taken on his behalf. Neither oral nor documentary evidence has also been adduced. There is no reason to defer the matter from the amount of compensation already awarded. There is also no scope to further enhance or reduce the amount of compensation already awarded. Taking into account the period of long pendency of the case, unwillingness of the petitioner to proceed further, and considering the heavy pendency position in the current situation, and also considering the facts and circumstances of this case, it is not found just and reasonable to further linger the matter. Hence, the order passed previously is confirmed.
So what is the wrong in this order?
My lord, they have not issued any notice, my lord.
Sure.
As per Section 20, your lordship has passed some similar orders, my lord.
How can we know that no notice has been issued?
My lord,
When
Annex
the
1, my
very first line, please listen to us.
my lord.
The very first line indicates that neither the petitioner nor the counsel is present today. On that day, no step has been taken, and it has been further mentioned also that you are not taking any steps, you are not remaining present in the court, and apart from that, it was a matter, reference is of the year 2004, and he decided the matter in 2023. What he could have done when you are not taking steps.
My lord, your lordship may see Annex 1.
If you say that in LA reference case you have not been noticed,
My lord.
then the very first thing is required to do is to produce the order sheet of
My
that
lord,
LA.
I have produced in some other case.
No, not in other case.
Your lordship may see.
Where is the order sheet of LA 352 of 2004?
4126, my lord.
We are not concerned with it.
My lord, your
If you
lordship may
produce
see.
the order sheet of another case, how can we know from that order sheet that in this case you are taking steps or no notice has been issued?
My lord, your lordship may Annex 1, my lord, page 10 and 11.
This is LMS case number. Just a minute. This LMS case number is 352. Let us say.
My lord, they have
352 order sheet kahin?
My lord, they have after this is computer number, my lord. Your lordship may see Surendranath Mohanty and 5 others. Page 10, last one, my lord. Because of my lord similar order passed, I have not applied the certified copy of all.
On similar order
only this branch, my lord. Other matter I have produced all certified copy.
We have to give a finding.
My lord.
If we say we set aside the order and remand the matter to give you an opportunity of hearing,
my lord.
We have to give a finding that yes, no notice has been issued to the petitioner.
My lord, your lordship may see.
For that, we have to pay you the order sheet.
My lord, your
because the impugned order indicates that on that particular day or even prior to that, you are not present. Your counsel was not present.
Your lordship may see page 11.
You are saying that you have been assigned with registration number 470 of 2013.
My lord, that
so
matter
all the dates.
ଆମେ
କଣ ପଚାରୁଛୁ ଶୁଣନ୍ତୁ
ସାର୍
ସାର୍ ଯୋଉଟା ପଚାରୁଛନ୍ତି ସାରଙ୍କ କଥାଟା ମୁଁ ଯେତିକି ବୁଝୁଛି ମୁଁ ଆପଣଙ୍କୁ ପଚାରୁଛି ସେଟା ଆପଣ କ୍ଲାରିଫାଇ କରନ୍ତୁ ଟିକେ ପେସେନ୍ସ ରଖନ୍ତୁ ଟିକେ ଆପଣଙ୍କର ରେଜିଷ୍ଟ୍ରେସନ ନମ୍ବର ଆପଣ କହୁଛନ୍ତି ଯେ 470/2014 ଯୋଉ ଆପଣ କମ୍ପ୍ୟୁଟର ସିଟ୍ ଟା ଲଗେଇଛନ୍ତି ଡାଉନଲୋଡ କରିକିରି ସେଥିରେ ସବୁଥିରେ ଲେଖଉଛି ଯେ awaiting SR କରିକିରି ଗଲେ ପ୍ରତ୍ୟେକ ଡେଟ୍ ରେ ଶେଷ ଇଏରେ ଲେଖିଲେ ଯେ 6/2/2023 ରେ ଡିସ୍ପୋଜେବଲ ଲେଖିଲେ ସେଇଆ ଆପଣ କହୁଛନ୍ତି କି
ସେ awaiting is ଏଟା କୋଉ କେସ୍ ଆପଣଙ୍କର କହୁଛନ୍ତି
ଏଇଟା ଏଇ କେସ୍ ଟା ସାର୍
କେମିତି ଜାଣିବେ
କାରଣ ଏଇଟା
ହଁ
ଦେଖନ୍ତୁ
ସେଟା
ସାର୍
ସେଟା ଦେଖ
ସୁରେନ୍ଦ୍ର ନାଥ ମହାନ୍ତି ଆଣ୍ଡ
ଏଠି
ଫାଇଭ
ଏଠି
ଅଦର୍ସ
ଏଇ ଯୋଉ 10 ନମ୍ବର
written
ପେଜଟା
in the annexure 1
just a minute 10
ସୁରେନ୍ଦ୍ରନାଥ ସ୍ୱାଇଁ।
ହଁ କରିଛନ୍ତି ନା କୋଉଥିରୁ ବାହାର ସିଆଇଏସ୍ ନମ୍ବର ଦିଆହେଇଛି ଆପଣଙ୍କୁ
ନାଇଁ ନାଇଁ
ହଁ
ଯୋଉଟା ସେଟା ଆସୁଛି ଫ୍ରିଲି ଆସୁଛି
E-courts.
ଇ କୋର୍ସ ଇ କୋର୍ସ
ନା ସିଆଇଏସ୍ ନମ୍ବର ଡାଉନଲୋଡ କଲେନି ପୁରା ନମ୍ବର ଆସିଥାନ୍ତା
ସେଟା ଆମକୁ ଦେବେନି
ସେଟା ଓକିଲଙ୍କୁ ପଚାରିଲେନି ଆପଣ ଦେବେନି କାହିଁକି
LA number 352 of 2004 ସାଙ୍ଗରେ ୟାର କନେକ୍ସନ କେମିତି ରହିଛି ବୋଲି ଆମେ କେମିତି ଜାଣିବୁ ମେ ବି that would be another case filed by the petitioners
No,
who
sir.
knows that
नो सर
ଆପଣ no sir କହିଲେ କେମିତି ହବ ଆମେ କନେକ୍ସନ ଟା ତ ପୁଣି ଗୋଟେ ରହିବା
then
ଦରକାର
I am filing
first title ଟା ଦେଖ
file petition CMA your lordship may see annexure 3 annexure 3 page 16
Hmm.
in that matter I have filed CMA application
no subject to what was said where is registry can be
ଷୋହଳ ନମ୍ବର ଆଇଟମ ରେ ବି ଏଣ୍ଟାର ଅର୍ଡର ସିଟ୍ ଟା ଦେଇଛି 16 ନମ୍ବର
ଅର୍ଡର
item।
ସିଟ୍ ଟା ଦେଲେ କିଛି ଅସୁବିଧା ନାହିଁ
ଷୋହଳ
ଅର୍ଡର
ନମ୍ବର
ସିଟ୍ ଟା ଦେଇନାହାନ୍ତି ସେଇଥିପାଇଁ ଆଉ
ଏଥିରେ ବି ଗୋଟେ ଅଖାଡ ରହୁଛି ଏଭରିଥିଙ୍ଗ ଆପଣଙ୍କର ଦେଖନ୍ତୁ 2013 ରୁ ଅର୍ଡର ସିଟ୍ ଟା ଯୋଉ ମେଣ୍ଟେନ ହେଇଛି ଏଭରିଥିଙ୍ଗ ଏସଆର କରି ପଳେଇଲେ
ହୁଁ।
ହଁ ଲାଷ୍ଟ କୁ ହଠାତ୍ ଡିସ୍ପ୍ୟୁଟ କଣ
ହୁଁ
ସାର୍ ଏଇଗୁଡାକ ଏଇ ଦିଟା ଅର୍ଡର ସିଟ୍ ରେ ଆପଣ ଦେଖିପାରିବେ ଆଗରୁ ବି
ସେଟା କେତେ ନମ୍ବର
ଗୋଟେ 4857 ଆଉ
4857 just
ହଁ
a minute, just a minute. ଗୋଟେ
ସେଟା ହଉଛି 16 ନମ୍ବର ଆଇଟମ
16 ନମ୍ବର ଆଇଟମ
ହଁ
ହୁଁ LMS case number 292 of 2004.
Again.
Petition under section 18
Again.
received.
ଏଇଟା ତ ପୁରା ଅର୍ଡର ସିଟ୍ ଟା ଅଛି ନା
No, ଏଥିରେ ପୁରା order sheet ଅଛି।
office note କରି ଗଲେ SR ପାଇଁ ଗଲେ put up for SR
ସବୁ ଏମିତି sir।
SR ହେଇଗଲା ପରେ 1/12/2006 ରେ SR last ହେଲା। ତାପରେ 20/2/2007 as 19th February is declared holiday due to sad demise of so and so, the record is put up on so and so, awaiting SR चल चलला awaiting SR 2008 2009 previous order not complied, comply the same.
ସେ ମୂଳକୁ ନୋଟିସ ଦେଲେନି ଆଉ ମୁଁ ବି ଗୋଟେ ପିଟିସନ ଫାଇଲ
SR awaiting SR ମାନେ କଣ ନୋଟିସ ଯାଇଥିବ ନା ନହେଲେ awaiting SR କେମିତି
ଆଉଟିଂ ଏସଆର ଲେଖିଛି ତ କିଛି ନୋଟିସ
ଆପଣ ଅବଜେକ୍ଟ ସେତେବେଳେ କରିଥାନ୍ତେ ନା
ଆମେ ଜାଣିଲୁ ସାର୍ ଆମେ ଜାଣିଲୁ ଯେତେବେଳେ ହାଇକୋର୍ଟରେ ରିଟ୍ ଗୋଟେ ଜଣେ ଫାଇଲ କଲା ଆମେ ଜାଣିଲୁ ସେତିକି ସେଇଥିପାଇଁ କି ମାଇ ଲର୍ଡ ହାଭ ପାସ୍ଡ ସମ୍ ସିମିଲାର ଅର୍ଡର and take cognizance of the under section 20 that no notice is issued.
ଏଟା କଣ ଗୋଟିଏ patch of land କୁ ଇଏ କରୁଛି ଗୋଟେ acquisition
ହଁ ଗାଁ ଲୋକ
connected
ଆଜ୍ଞା ସବୁ connected ମୋ ଗାଁ ଲୋକ ସବୁ Your lordship has passed order 31 matters your lordship has passed order. If your lordship say I will
appear kale
it will be better if you
But so far as this record is
study the order sheet why
see କରନ୍ତୁ ନହେଲେ registry ରେ ଯାଇପାରେ
କୌଣସି କେସ୍ ଆପଣ ଅର୍ଡର ସିଟ୍ ଦେଇନାହାନ୍ତି
ନା ନା ଅନ୍ୟ ଗୁଡାକ ଦେଇଥିଲେ ଏଇ
ନାଇଁ ମୁଁ ଆଜି ଯେତିକି ଲିଷ୍ଟ ଅଛି
ଆଜିରେ ଦିଟା ଦେଇଛି ଆଉ ଅନ୍ୟ ଗୁଡାକରେ
ଆପଣ କୋଉଥିରେ ଅର୍ଡର ସିଟ୍ ନାହିଁ କୁହନ୍ତୁ ଆମକୁ କହିବ ଆପଣ ଅର୍ଡର ସିଟ୍
ଏକ ଦୁଇ ଏଇ ଯୋଉ 4126 ରେ ଅଛି ଆଉ
4126 ରେ ଅଛି ତାପରେ
ଆଉ ଗୋଟେ ହଉଛି 4857
4857 ସେ ଦିଟାର କଭର ମ୍ୟାଟର ହେଇଯିବ ମାନେ ଅର୍ଡର ସିଟ୍ ଅଛି ବୋଲି ଦିଅନ୍ତୁ ତାର ଅର୍ଡର ଦିଅନ୍ତୁ 4126 ଟା ବାଦ
Since then, till date, the more than 18 years have been elapsed. The Honorable High Court is proceeding back to dispose of this.
ଆଉ ଯୋଉଗୁରାକ ମୁଁ ଇଣ୍ଟରନେଟ ରୁ ନେଇ ଆସିବି ଯେ କନେକ୍ଟେଡ ଦେଖା ଯାଉଛି ଯେ 352 କି 354 ଏଲକେସ୍
ହଁ ସେଇଗୁଡାକ ନେଇ ଅସୁବିଧା ଏଟା କରେକ୍ସନ କରି ଦେଇ ଦେଇଛନ୍ତି
ହଁ କରେକ୍ସନ ସାର୍ ଯୋଉ ୱିଦିନ 3 months ଯୋଉଟା ହେଟା ଟିକେ ସାର୍ କାଟିଦେବେ ଆଉ ଟାଇମ ଦଉନାହାନ୍ତି
Special order pass ହେଇଥିଲା।
ହଁ ଠିକ ଅଛି ଆଜ୍ଞା
ଏଇଟା ଏଇ ଯୋଉ 4126 ରେ ଏଇଟା କରିଦେବେ। ଆରଟା
ଆଉ ଗୋଟେ ଦେଇ
4857 ଆଉ ଗୁଡାକର ବାକି ଗୋଟେ କମନ ଅର୍ଡର କରିଦିଅନ୍ତୁ। ଦି ଲାଇନ୍ କାଉନ୍ସିଲ ଏଇଟା କଣ ଏଇଟା ରଖନ୍ତୁ। ସେ item number 14 of first item ରେ ଯୋଉ order
There are two cases. One case, the merit order has been passed on annexure 2. On to this. And another case is ex parte.
କୋଉଟା?
But 4126, if your lordship will see annexure 2,
4126
again. Annexure 2 starts with page 23. Now, ordering portion, if your lordship will see, that is on merit.
confirming the judgment
Yes.
without issuing any
ନୋଟିସ
notice.
ରହିକିରି କଣ
Just
notice in
ଆପ୍ୟର କରିଛନ୍ତି ନାଇଁ କୁହନ୍ତୁ।
ଅର୍ଡରଟା ଏ ଅର୍ଡର ସିଟ୍ ଟା ପୁରା ଦେଖୁଛି କି ଆପିୟର କରୁନାହାନ୍ତି ବୋଲି।
Without issuing any notice.
Yes.
ଆପଣ annexure 1 କୁ ପଳେଇ ଆସନ୍ତୁ। ଅର୍ଡର ସିଟ୍ ସବୁଠି ଦେଖୁଛି awaiting SR ସେଇ ଟାଇପ
ସେଟା
ର ହିଁ
ହେଇଗଲେ ସେ
ଚାଲିଛି।
କରୋନା ପିରିୟଡ ଟା କଭର କରିଦେଲେ। କରୋନା ପିରିୟଡ ପରେ ଭୁଲିଗଲେ ଯେ ଏସଆର ହେଇଛି କି ନାହିଁ। ମାନେ ସର୍ଭିସ ହେଇଛି କି ନା ଆଟଲିଷ୍ଟ ଗୋଟେ ତ ଅର୍ଡର ଟା ରହିବ ନା ଅମକା ଡେଟ୍ ରେ ସର୍ଭିସ ହେଇଯାଇଛି ବୋଲି ଏଡିଟା ରେକର୍ଡ ରହିଲା ବୋଲି।
My lord, they are taking a plea that issuance of notice is not required. That is why I have come before your lordship. The section 20 itself says that after order passed by LA authority, thereafter reference court should issue notice to the interested party that they have forgotten and all matter they have dismissed, my lord, without issuing any notice. That is why I have come before your lordship.
WPC number 2692 of 2025. The petitioner Devi Prasad Das has challenged the order dated 6/2/2023 passed by the senior civil judge in LA case number to seta LA case number 352 of 2004. LA miss case number na LA case? LA miss case number 352 of 2004. The main ground that has been taken by the Land Council for the petitioner to set aside the impugned order is that after the case was referred, no notice has been issued to the parties, including the petitioner. And the case status report, which has been annexed to the writ petition as Annexure 1, would indicate that on all the dates, the case was adjourned for awaiting SR. And all on a sudden, it was disposed of on 6/2/2023. And therefore, it would be clear that in this case, before the service of notice on the parties, particularly the petitioner, the writ petition, the impugned order dated 6/2/2023 has been passed. You are relying on this 90 Supreme Court?
Well, two decisions.
No.
In one case, they have not issued any notice to the party, and he has filed one writ application. first matter, and that a writ application is allowed, and the state go to SLP, and SLP confirm the order,
In
and hold that
the Land
issuance
Council for the petitioner has relied upon the decision of the Honorable Supreme Court in case of Swan. The decisions are taken on record. However, we do not find the LM case number 352 of 2004 in the case status which has been annexed to the writ petition as Annexure 1. Though the filing number and registration number and registration date have been mentioned in Annexure 1. The Land Council for the petitioner seeks some time to produce documentary evidence that Annexure 1 is related to LM's case number 352 of 2004. How much time you require?
my lord, 7 days.
Within a period of 7 days, he seeks to release this matter and will commence from 17th of March 2025. Hello?
18.
18th, all right, 18th percent, 18th March 2025. ସେଇ ଟାଇପ୍ ର ଅର୍ଡର ଗୁଡାକ ଅନ୍ୟ ଗୁଡାକ ଦେଖିକି ଖାଲି ଚେଞ୍ଜ ହବ ହେଲା ଆଉ ବାକି ଯେତିକି ଅଛି ଦିଟା ଆମେ ଡିସ୍ପୋଜ କଲୁ ବାକି ହଁ ହଁ ଠିକ
ସେଟା 7/3 କୁ appearance date,
କୋଉଟା
ସେ ଯୋଉ ଦିଟା ଡିସ୍ପୋଜ ହବ
ହଁ
7/3
ଡିସ୍ପୋଜ ଅଫ କେସ୍ ରେ ଯୋଉ ଡେଟ୍ ଟା ହେଇଛି ଆଉ ସେ ଯୋଉ 3 ମାସ ଲେଖା ହେଇଛି ସେଟାକୁ କାଟିଦେବେ କାରଣ ସେ ଟାଇମ ଦଉନାହାନ୍ତି ହରିଟ୍ କରୁଛନ୍ତି ସେଟାକୁ କାଟିଦେବେ. Yes. Just take it. We are just coming with information.
My lord, probably item number 25, which was heard by the regular bench. I think
No, it cannot be taken up because
Yes.
it's just.
I
So
will
all
play
these
on-
matters will come on. We are taking up this fresh admission matter, and these hearing matters will take up on Monday.
by the regular.
Right? Obviously,
Yes,
on
yes.
Monday.
I wanted to know that so that I can.
No, it's, you're free to go. Yes.
Item 15.
That's item 15, my lords,
Yes.
is directed to take instruction why that calculated amount has not been paid, my lords. We have received the written instruction, my lords. Here, my lords, the amount is correct and it has not been received by the concerned authority. That's why we concerned authority, the special land acquisition officer has requested to pay for 3 weeks time. Within three months, within that it will be paid. So I want to file this by an affidavit so that it can be disposed of and the amount can be disbursed
All right.
within that period.
So when you want to file that affidavit?
Within a week we'll file.
Within a week. All right.
Let's be here. They have paid in respect of another applicant, which the amount was sanctioned.
He's not disputing that. He has stated that
He has detailed instructions.
he has received the detailed instruction. He wants to file. That would be for your benefit. Why are you?
They have given to one and another person they have not paid.
That is the difficulty.
Sir, he wants to file an affidavit saying that he is not disputing this amount and if time is granted, they will be disbursing.
Yes.
That is what he says. Please understand.
Start time.
Yes,
So,
sir. He's giving 1 week time. As for the Land Council for the state submits that as per the order dated 12/2/2025, he has already received detailed instruction and he wants to file the same with an affidavit. Put up this matter and one is handled, one is this matter and we will mention. So let it come on, if you want 1 week, then can it be on 10th or 17th?
10th.
It is 10th. Okay, 10th. All right.
Item 17.
Item 17, my lord, the land of the petitioner has been and
land of the petitioner
has been acquired by the opposite party number 3 and compensation amount was also paid under Annex 2.
Yeah.
Only compensation amount has been paid. And as per the rehabilitation assistance rules and no other benefits were given. For that, the petitioner has put forth his grievance before the learned collector, which is pending under Annex 3.
The Annex 3 was presented on 31st January.
The January 25.
So it is not that inordinate delay, Mr. Misra. ସେ କଣ କି ସିଆଡେ ଗୋଟେ ରିପ୍ରେଜେଣ୍ଟେସନ ଦେଇଦେଇକି ଆପଣ ଯେତେବେଳେ ରିଟ୍ କୋର୍ଟ କୁ ପଳେଇ ଆସୁଛନ୍ତି it was received just on and
received on
31/1/2025. It's not that it is such an inordinate delay that we will direct that you consider.
The period fix କରିବା ପାଇଁ କହୁନି, let him consider it.
Obviously, it has already been received.
Period ଟା fix କରିବା ପାଇଁ କିଛି କହୁନି.
Petition has been filed by the petitioner, Dharmendra Maji. Dharmananda Maji for a direction to the opposite party number 2, na?
2.
Opposite party number 2 to dispose of the representation under Annex 3 in accordance with law. It is the contention of the Land Council for the petitioner that where have you stated that which thing has not been paid to you?
My lord, that I have stated in para 1, I have stated, and
paragraph 2 ଏହି ଜାଗାରେ କ୍ଷତିପୂରଣ ସଂଖ୍ୟାକୁ ଆମେ ଆପତ୍ତି ଥାଇ ଲିଖରେ ଗ୍ରହଣ କରିଅଛୁ କିନ୍ତୁ
ନାଇଁ
ଆମ
ଏଇ ଯୋଉ ଆମର ପାରାଗ୍ରାଫ ଇନ୍ ଦି ରିଟ୍ ପିଟିସନ
writ petition para 1 I have stated, and also on subsequent paragraph also I have stated. At
para 7 ରେ କହିଛନ୍ତି
ହଁ para 7 ରେ କହିଛି, para 4 ରେ ବି ଆଜ୍ଞା ଲେଖିଛି।
ଆଚ୍ଛା, the land council for the petitioner submits that the petitioner is the recorded tenant of land under khata number 122, plot numbers 92, 89, 92 oblique 2961 of Mauja Ambapala in the district of Angul, and the said land along with the lands of the co-sharers have been acquired by the opposite party, but the rehabilitation benefits as per the guidelines prescribed under the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013, as well as adequate amount as compensation has not been paid, for which the representation has been submitted. The Land Council for the state submitted that since the representation has been received on 31/1/2025 by the opposite party number 2, the petitioner should not have opposed this court for disposal of the representation. Be that as it may, since representation has already been submitted before the opposite party number 2, the same shall be considered in accordance with law. That's all we can say. Yes.
Item 18.
May I please, my lord, in this case, the petitioner's land has been acquired, head annexure 1. They have issued notice for receiving compensation of such amount. My kindly have a glance to annexure 4. That as per the report of the RI and sub-register Bethnati, I have to get more compensation. My grievance is that let the compensation be awarded as per the benchmark valuation by annexure 4. To that effect, I have given representation to the collector by annexure 5.
17/2/2025.
अरे सेम जिनिस सियाड फाइल कर दोजंदी याडा सी रेट फाइल कर
सीटा होची compensation amount benchmark valuation ने अधिकार होची ते माने कम award करचंती, so we have given representation to nothing more.
No, the prayer is for this representation dispose of, but when you file the representation on 17/2/2025, how can you expect that
10 दिन भी देलेनी
ताको भी टाइम देवे ना, खाली से आउ किछ काम नाही से बसचंदी आपण तो अनै कि नहीं सेम ऑर्डर कर दियंतु रिप्रेजेंटेशन हैज बीन फाइल्ड द रिलेवेंट पैराग्राफ कर दिन सेटा देखि ये कर दे अब टाइम फिक्स अप करिवे डिस्पोज ऑफ द रिप्रेजेंटेशन in accordance with law.
As per annexure 4, my lord,
Data sema we do not know. Annexure 5 representation is there. So same order in other matters also.
My lord, 18 and 19 both are true.
18, 19, 20.
20 is not mine, my lord.
Acha, 18, 19 data.
My lord.
18, 19 data representation disposed.
Obliged.
Yes.
Item 20.
Nobody is there. These are of matters of Vijay Kumar Behra. Era Rocky to next week, huh? Non-appears कर दियंतु. Place this matter on 4th कर दियंतु. 4/3/2025 ହେଲା 3ଟା matter 20, 21, 22. Yes.
Item 23.
Yes.
Your Lordship, IA for substitution has been filed and is appearing for OP number 4, Your Lordship.
I have instruction to appear for the Lord substitution parties. OP number 4. I have instruction to appear in course of the day. I will file my Bhinama.
Okay.
Against opposite party number 4.
Yes,
Respondent number 4.
That you substituted legally.
4A to 4E.
4A ରୁ 4E
Yes, Your Lordship.
ଆପଣ ଆଜି ଫାଇଲ କରିବେ ନା ନା ଲେଖି
IA to follow
ଫାଇଲ କରିଦେଲା ପରେ disclosure କରିଦେବେ IA number ହଁ ଆଜି କରିବେ ତ
ଆଜ୍ଞା
IA number 61 of 2025 is an application for substitution of the successor of the legal heirs of deceased respondent number 4. Nada con respondent number 4. Madan Jena.
Yes, Your Lordship.
Madan Jena. The Land Council for the Swan Procedure submits that he has instruction to appear for all the legal heirs of the said respondent number 4 and he will file Wakalatnama in course of the day. Put up this matter in the week commencing from 10th of March 2025. Actually, say the name of it.
Respondent number 5.
5.
The Land Council for the respondent number 5 is present.
Respondent number 3.
6. Na de diyo. 6.
1 2 ଆପଣ ଅଛନ୍ତି ଆପଣ ଅଛନ୍ତି କି ଅଛନ୍ତି 1 2 Commissioner consultation officer ଆପଣ ଅଛନ୍ତି ଆପଣ ଅଛନ୍ତି
ହଁ ସେଠି ଲେଖିଦେବେ ନା ସବୁ ଦଉଛନ୍ତି କିଏ କାହା ପାଇଁ ସେଟା ଲେଖିଦେବେ ସେଟା କାହା ପାଇଁ ଲେଖି ଦିଅନ୍ତୁ you are for respondent number 6 with your name so matter is to be listed on 10th March 2025. Yes.
Item 24.
For my lord, according to my calculation, 9 days delay in filing the appeal. The other side was noticed.
There is 15 days delay.
I guess 15 days देखिए
15 days दिखाई so
other side notice ही फिला perhaps is
when notice was issued
as early as 17/5/2019
on this limitation matter.
Okay.
तो कि appear करनी
हाँ appear करचंती
और किछ कहूनांती से
appear करचंती counter file करनांती but in the meanwhile it was dismissed on for non-appearance on 27/10/2022 thereafter it has been restored
ସେ ସବୁବେଳେ କୋର୍ଟ ଭିତରକୁ ପଶିଲା ବେଳକୁ ସେ କେସ୍ ଟା ସରି ଯାଇଥାଏ
ଆଜ୍ଞା
ଶୁଭ୍ରାଂଶୁ ଭୂଷଣ ମହାନ୍ତି ଯେତେବେଳେ ପଶନ୍ତି ସେ ତ କେସ୍ ଟା ସରି ଯାଇଥାଏ ସେ ଆସିକି ମେନସନ କରନ୍ତି
writ appeal was dismissed for non-prosecution
ନାଇଁ ତାପରେ 22 ରେ
restored ହେଲା ପରେ
ତାପରେ ରେଷ୍ଟୋର ହେଇଗଲା ରେଷ୍ଟୋର ହେଇଗଲା ସେଇଥିପାଇଁ ଏଟା ଲିମିଟେସନ ଟା ପୁଣି ଉଠିଛି
ଓରିଜିନାଲ
9 days delay more according to me 15 दिन delay
हम एसआर ଦେଖିଛନ୍ତି 46
15 days
but total period is 46 out of that limitation 30 then certified copy period 1 day so delay is 15 days
Mr. Anindya Kumar Mishra and counsel for the appellant is present. None appears for the respondent. List this matter next week.
Conviction bail matter. Modification order next time. Please. There is appeal against conviction. I know I'm released now.
Supplemental list, item number 1.
That special court act matters because your lordship didn't hear because Madam Justice Otto was party. Any other basis constituted, your lordship can look up that matter. Today it is not. No, I know it's not previously known. So only I'm reminding your lordship. All right, I'll ask the registrar. Yes. Right.
Appeal against conviction for the offense 302 of the IPC.
Life imprisonment. Like admit for the trial court records.
Item 2.
May I please, your lordship? In this case, your lordship, last applicant directed to hand over the evidence of the PW5 and 13 to the State Council. It's a for bail, your lordship. The petitioner is inside.
You have received the copy?
Yes, sir. We have received the copy, but that is incomplete. That is 13 is the evidence of the doctor.
Doctor in PW5.
PW5 is
PW5 is the circumstantial.
No, whether he is having the deposition copies of all the witnesses or only two witnesses?
Two.
Why do not giving supply? You are moving a bail application in a 302 matter.
Yes, sir.
You will selectively give only two witness deposition copy.
Only circumstantial for that. Then sorry, your lordship, I will give.
Whatever it may be, you have to give.
I will give it.
The Land Council for the state submits that the Land Council for the appellant has supplied the deposition copies of only two witnesses, that is PW5 and PW13.
Yes.
However, in the trial court, 15 witnesses have been examined. So far, let the Land Council for the appellant supply the deposition copies of the rest of the witnesses to the Land Council for the state.
By tomorrow, your lordship.
By tomorrow, no, by Monday.
By Monday.
By 3rd of 2025. Place this matter on 5th of March 2025.
Okay.
Yes.
Item 3.
Item 3 may be
the IA number 1001 of 2018 for bail liquidate. Yes. Which order?
10th February.
10th February.
Based on time because I am not.
So 13 years is in custody. Kendrapada jail. So
next week.
Next week. All right. You mention it IA number 291 of 2025. This is an application for bail. Land Council for the state seeks some further time to obtain the custody certificate of the petitioner. Put up this matter next week.
Any specific date?
Okay, 5th, 5/3/2020.
Obliged.
Item 4.
Item 4, your lordship, call for the reference file. 1 of 2011. Reference file, my lord.
1 of 2000.
Criminal records Act of 2011, where he was acquitted since 2019, but this still JCRL is pending for ratification. Their video lordship is directed to produce that.
Their
13/2025.
The infant order is separate, so that the appellant along with function so they trial in the court of function. The judgment and order dated by the court is the executor of the charge. The appellant was found guilty under section 302. No sentence was passed out from the documents produced by the Samsung. It appears that the criminal reference from once this court has been ceased to set aside the conviction sentence of the appellant passed in the court to set out according to the release order. So that order has been passed in the reference.
That record is one. That order is the details order was passed by this Honorable Court.
So this JCRL is just disposal. See.
Peruse the order passed in whatever criminal reference to
Order number 13.
peruse the judgment and order passed in dated 39/2019, passed in criminal reference number 1 of 2011, in which the condition of the appellant under section 302 as per order dated 23/7/2011 passed by the London ad hoc additional session judge Sundargarh in ST case number 151/35 of 2010 has been set aside and the appellant has been directed to be set at liberty if his detention is not required in any other case. Since the present JCRLA has arises out of the impugned judgment and order of conviction, which is the subject matter of CRL REF number 1 of 2011, and the acquittal order has already been passed, this JCRLA is disposed of. Yes. And Mr. Tushar and Mr. Lanana Maita Spirit. Yeah.
Item 5.
My lord, in this case, matter of the year 2022, the appellant requested me to file an appeal.
You are Mr. Sabyasachi Mishra.
Yes, madam.
You filed a criminal appeal.
992 of 2022.
No. You filed earlier against the self-same judgment. You earlier filed a criminal appeal 377 of 2018, in which the appellant has been sentenced to life imprisonment. Just listen to us. You are the counsel for the appellant. That matter was admitted and that was sub judice. Again, you filed another criminal appeal. That criminal appeal is 992 of 2022. That means this present criminal appeal. So, in the earlier criminal appeal which you filed, the conviction of the appellant has been under section 302, that has been altered to 304 part 1, and he has been sentenced to RI for 10 years and to pay a fine of rupees 20,000. Now this present appellant. So question is that when you are filing, how you are filing the second criminal appeal arising out of the self-same judgment? If somebody else should have been the advocate,
Yes.
matter is different.
Yes.
From your chamber against the same judgment, how you are challenging in two criminal appeals?
No. Initially, another advocate was there.
So ଯେତେ ଜଣ advocate ଆପଣଙ୍କୁ ଆଣିକିନି ସେ impugned judgment ଟା ଦେବେ, ଆପଣ ସେତେଟା appeal କରିବେ, ଏଇଟା ହଉଛି ଆପଣଙ୍କର
ନାଇଁ ସେଟାରେ ମୁଁ ନଥିଲି, ସେଟାରେ
ଲେଖା ହେଇଛି।
ସବ୍ୟସାଚୀ ମିଶ୍ର ପ୍ରିଜନର ପିଟିସନ ସେ ଦେଇଥିଲା, ତାପରେ ମୁଁ କହିଲି ତା ଦେହରେ ମୋର ଭକାଲତ ପାୱାର ନାହିଁ।
Are you not the counsel in the earlier criminal appeal?
ନାଇଁ ସେଇଟାରେ ମୁଁ ଭକାଲତନାମା ଫାଇଲ କଲି।
In CRLA number 377 of 2018.
ନାଇଁ ସେଟାରେ ମୁଁ
Just
ନଥିଲି,
377 of 2000.
ସେଟାରେ ମୁଁ ଭକାଲତନାମା
Wait.
ସବସିକ୍ୱେଣ୍ଟଲି ଫାଇଲ ରୁ ସେ ମତେ ସିଗ୍ନେଚର କରି ଦେଇଥିଲେ।
We do not know.
ଅଲଗା ଆଡଭୋକେଟ ଥିଲେ ତା ଦେହରେ, ମିଶ୍ର ଆଉ
ଶକ୍ତିଧର ମିଶ୍ର।
ହଁ ମୋର
377 ଅଛି
ଡକ୍ୟୁମେଣ୍ଟ ଜେଲରୁ ପଠେଇଥିଲା ମିଶ୍ର ଆଉ
377
ଏଇଠି वकालतनामा
फाइल ऊपर देखिलो, ऊपर ना लिखा है सब्यसाची मिश्र प्रथम पेज टा पर
ଏଠି ଲାଷ୍ଟ वकालतनामा ଏଠି ଆଉଟି ତଳକୁ ଆସ।
ଏଇଠି ଲେଖା ହେଇଛି।
ହଁ ନାଇଁ ସେଠି ଛାଡ଼ନ୍ତୁ, वकालतनामा ଏଇଟା।
You filed your वकालतनामा was filed in CRLA number 377 of 2018.
Again,
when it was filed by some other advocate. Thereafter you filed वकालतनामा. So the earlier advocate's power ceased. ହେଲା ଆପଣ ଫାଇଲ କଲେ 19/2/2022 ରେ।
22 ରେ ଯେତେବେଳେ ମୁଁ ଫାଇଲ କଲି,
ତାପରେ ଏଇ କ୍ରିମିନାଲ ଆପିଲ ଟା କେବେ ଫାଇଲ କଲେ? 992 ଟା
992 2022 ରେ।
ସେଇଆ ପରେ ଆପଣ କହୁଛୁ, ଆମେ ଆପଣଙ୍କୁ କହୁଛୁ ଯେ ଏଇଟା ଫାଇଲ କରିଛନ୍ତି 4/11/2022 ରେ। 4/11/2022 ରେ ଏଇ ଯୋଉ ପ୍ରେଜେଣ୍ଟ କ୍ରିମିନାଲ ଆପିଲ ଟାକୁ ଆପଣ ଫାଇଲ କରିଛନ୍ତି, ଠିକ ନା ନାହିଁ? ଆର କେସ୍ ଟାରେ ଯୋଉଟାରେ CRLA ନମ୍ବର 377 ରେ
October.
आपण फाइल करछंती वकालतनामा on 19/2/2022
ଚାରି କୋଉଟା କହିଲେ
ନା
99/2/2022 ରେ ସବ୍ୟସାଚୀ ମିଶ୍ର and ସେମ୍ ଓକିଲ 4/10/22 ରେ ଏକ୍ଜିକ୍ୟୁଟ ହେଇଥିବ
execute ହେଇଛି but criminal appeal was
ଫାଇଲ
filed
କରିଛନ୍ତି ହଁ
criminal appeal was filed on
4/11/2022
4/11/2022 right
4/11/2022
ଏବଂ ଏଇ ଯୋଉ ପୂର୍ବ କେସ୍ ଟାରେ ସିଏ ଫାଇଲ କରିଛନ୍ତି ଓକାଲତନାମା on 19/2/2022 ଯୋଉଟା ଦେଖୁଥିଲେ
sir 19/2
so
ସେଟାରେ ଇନିସିଆଲି ଆଉ 2 ଜଣ ଥିଲେ ମିଶ୍ର ବାବୁ ବୋଲି ମିଶ୍ର ବାବୁ ଆଉ ଜଣେ ଆଡଭୋକେଟ
ସାର୍
ଥିଲେ ମୁଁ
ପୁରା
ତାଙ୍କୁ
ନାଁ ଲେଖା ହେଇଛି ସାର୍ ଆପଣଙ୍କର
ହଁ ମୁଁ ଫାଇଲ କରିଛି ଓକାଲତନାମା ସେ
ଓଡିଶା ଷ୍ଟେଟ ବାର କାଉନସିଲ ନାଁ ସହିତ ଆପଣଙ୍କର ସେମ୍ ଓକାଲତନାମା ସେମ୍ ଓକିଲ ମାନେ ସବ୍ୟସାଚୀ ମିଶ୍ର ଦୀପ୍ତି ମହାପାତ୍ର and S ମହାପାତ୍ର
you are not the associate you are the main counsel so if you are the main counsel and you accepted a brief and subsequently another advocate would come with a wakalatnama and with the judgment copy and will file criminal appeal. It's a live conviction. Let us say this matter would not have been come to our notice. What would have happened? Hela? Jodi e jinso amku ame cheypai to explanation call for korchu office ru gote same judgment aji heigala 302 taku alter karigini 304 part 1 heigala काली सकाळे मनकर एई अपीलटा एतिक नोटिस को न आसता आमे जजमेंट को जदी माने कंफर्म कर दी तांतु तल कोन अवस्था हिता दीटा दीटा पॉसिबिलिटीज देयर सो अन्य कोनसी चैम्बर हेतिल अलगा कथा यू आर द काउंसिल इन बोथ द केसेस and you are taking it very casually no कोन आपण यार कॉन्सिक्वेंस ता कोन आमे जो लाइट रे आमे आपण कहूचू आर यू फॉलोइंग इट और नॉट अर्लियर क्रिमिनल अपील रे सेम लोक सेम जजमेंट रे 302 को 304 पार्ट 1 हेगिनी 10 वर्ष तक हो गला एई क्रिमिनल अपील टारे सपोज एई आगो जिनसटा को आमे स्टेट काउंसिल नोटिस को आनी न थांदा तो पॉसिबिलिटी अछि जे आमे ताको लाइव कन्विक्शन को कंफर्म कर दी थां ताहले दीटा डिवीजन बेंच गोटे सेम जजमेंट अगेंस्ट रे 304 पार्ट 1 ने 10 वर्ष करछंती आ गोटे डिवीजन बेंच लाइफ कन्विक्शन को कंफर्म करछंती आर यू फॉलोइंग व्हाट वुड बी द consequence so whatever you want to say please file with an affidavit otherwise you will refer the matter to the bar council it's not a thing which is to be lightly taken whatever आपण जहा कहबा चाहउचंती by way of an otherwise you will refer the matter to the bar council it would not have been different आपण होइजन the main council and what is the report which has come in sealed cover seman kay point out करना let us it escaped my notice to verify the FIR details. This is the report of the superintendent.
Superintendent से confirm करते हैं the register gets confirm करते हैं upon verification सब जानिबा इसको कुछ नहीं
FIR detail एटा ना
ए जो टैग है जो
हां एटा से माने प्रथम रे देखिबा
सिस्टम टा से देखुतला
हां अरे beautiful and you see the number is there also जो earlier number is there 377 number is there
तो
ଏଇଥିରୁ ତ ଷ୍ଟେଟ୍
ହଁ
କାଉନସିଲ
ମୁଁ
ବାହାର
ମୁଁ ଦି
କରି
ତିନି ଥର
point out
ଦେଖୁଛି
କରୁ।
ମୁଁ ବି ଯେତେବେଳେ କରୁଥିଲି
ହୁଁ।
କ୍ରିମିନାଲ କେସ୍ ଗୁଡା ମୁଁ ବି ଏଟା ଦେଖୁଥିଲି
How it is their job.
482 ଗୋଟେ ଥରେ ବସିଥିଲା
How
ମୁଁ ସେଥିରେ ବି ଦେଖୁଥିଲି
how they
482 ସେପଟେ 407 ସେପଟେ ମୁଭ୍ କରିଥିବେ very sensitive and serious thing.
I want to say, my lord,
See,
Mr.
Mr. Sabyasachi, kindly understand, you are the leading counsel in both the appeals, and you have been uh, uh, with this similar signature.
377 ସେଟା ମୁଁ advocate ନଥିଲି
Sir,
Do I want a proceeding now?
no my lord
Then we are asking you.
ନାଇଁ ମୁଁ କହୁଛି ଅଲଗା advocate
It was your
ସେଟା
duty.
ଆମେ ଦେଖିଲୁ
It
ସେଟା
was
ଆମେ
your
ଦେଖିଲୁ
duty.
Sir, ସେଟା ଆମେ
When
ଦେଖିଲୁ
you are filing a criminal appeal in 2022, 2000 criminal appeal number 992 और 2022 रे आपण जेतेबेले क्रिमिनल अपील टा फाइल करचंती जो जजमेंट होची 3/4/2018 रो आपनकर फास्ट ड्यूटी हवा कथा दरकार अरे ट्रायल कोर्ट जजमेंट अगेंस्ट रे आउ क्रिमिनल अपील फाइल नी तो
ବୋଧେ ଏଇଆ କହିବା ପାଇଁ ଚାହୁଁଛନ୍ତି କି ଆପଣ ବ୍ରିଫ୍ ଟା ନ ଦେଖିକିରି वकालतनामा ଜଣେ ଦେଲେ ଆପଣ ଫାଇଲ କରିଦେଇଥିଲେ ତାପରେ କ୍ରିମିନାଲ ଅପିଲ ଟା ଥରେ ଆସିଲା ତାପରେ ଆପଣ ଫାଇଲ କରିଦେଲେ
सेकंड अपील टा आपण ड्राफ्टिंग
ଏଇଆ
करी
ହଉଛି
फाइल करचंती सेकंड क्रिमिनल अपील आपण निज ऑफिस रे ड्राफ्टिंग हेकिनी फाइल ही ताले
ସେକେଣ୍ଡ ଟା ଆପଣ ମାନୁଛନ୍ତି
ସେକେଣ୍ଡ ଟା ମୁଁ ମାନୁଛି
ଫାଷ୍ଟ ଟା ଆପଣ
ମୁଁ ଫାଇଲ କରିନଥିଲି
କି ମନା କରୁଛି ଫାଷ୍ଟ ଆପଣ ତାପରେ ଆପଣଙ୍କ ଆସିଛି ଅଫିସ କୁ ଆସିଛି ଆପଣ वकालतनामा ଦେଇଛନ୍ତି ଆଗ କାଉନସିଲଙ୍କର ନାଁ କଟିଛି ଆପଣଙ୍କର ନାଁ ପଶିଛି ତା ଦେହରେ ଆ ବ୍ରିଫ ଆପଣଙ୍କ ଚାମ୍ବର ରେ ଅଛି
ଆପଣ ଭେରିଫାଇ କରୁନାହାନ୍ତି ଦି ଯାକ କ୍ରିମିନାଲ ଅପିଲ ଦେଖିଛନ୍ତି ଆପଣ वकालतनामा ଗୋଟେ ଆସିଲା ଫାଇଲ କରିଦେଇଛନ୍ତି ବ୍ରିଫ ଟାକୁ ମିଳେଇ ନାହାନ୍ତି ଆଉ କଣ ଆଉ ସେମିତି କଲେ କଣ ହବ ହାଁ
peruse the peruse the reports peruse the explanation submitted by the superintendent criminal appeal section so also the dealing assistant in CRLA number 992 of 2022 the explanation are taken on record for them the Land Counsel for the appellant has filed a memo for review of the CRLA, which is taken on record. So it appears that the appellant Prashant Meher filed CRLA number 377 of 2018 challenging the impugned judgment and order dated 3/4/2018 passed by the Land and Session Judge Nuapada in ST case number 74 of 2015 through advocates Shaktidhar Mishra and A.K. Nando on 8/5/2018. Subsequently, Mr. Sabyasachi Mishra and his associates filed wakalatnama in the said CRLA number 377 of 2018 on 19/2/2022, and accordingly, the names of Shaktidhar Mishra and A.K. Nanda were deleted, and Sabyasachi Mishra and his associates were shown as the advocates of appellant Prashant Meher in CRLA number 377 of 2018. While the said CRLA number 377 of 2018 was sub judice, the present CRLA 992 of 2022 was filed by Mr. Sabyasachi Mishra and his associates on 4/11/2022, and even though the FIR details match for search criteria, indicates that at the time of filing of CRLA number 992 of 2022, CRLA number 377 of 2018 was pending, but in the certificate portion, the London Council has mentioned that the matter out of which the criminal appeal arose was never before this court in this form, as for instruction received from the appellant. This certificate portion is not correct in view of the pendency of the earlier criminal appeal filed by the appellant in CRLA number 377 of 2018. Let the London Council for the appellant, Mr. Sabyasachi Mishra, file an affidavit explaining under what circumstances, when he had already entered appearance in CRLA number 377 of 2018, while filing Wakalatnama on 19/2/2022 for the appellant Prashant Meher, how he filed this criminal appeal on 4/11/2022, which was challenging the self-same judgment and order of conviction. Put up this matter in the week commencing from 10th of March 2025. The explanation furnished by the dealing assistant and superintendent shall be considered on that day. Yes.
Item 6.
Yes, what happened about the service of notice on the informant? Pass on. All right. The London Council for the State has produced the written instruction received from IIC Chaudhar Police Station, Cuttack, UPD, showing service of notice on the informant, so also the victim, which have taken on record. Stop. none appears for the appellant put up this matter in the week commencing from 17th March 2020.
Item 7.
Please, Your Lordship. On behalf of Mr. Panda, Your Lordship, I pray for one week adjournment, Your Lordship.
Last thing my lordship, that is the passport certificate as well as the physical accident. We will receive the physical accident and passport certificate, but passport certificate is not in the form. So I will let it go next week. We can file the that.
Custody certificate is not in proper form, but you have received instruction about the criminal antecedent. তাহলে সে ক্রিমিনাল অ্যান্টিসিডেন্টটা ফাইল করবো না দি আরটা আমি টাইম দিয়ে দઉଛୁ the learning council for the state submits that he has received instruction regarding the criminal antecedent against the appellant, and he has filed the instruction, written instruction from so and so. The same is taken on record. Land Council for the state further submits that the custody certificate which he has received, custody certificate of the appellant which he has received from the concerned jail superintendent is not in proper format, and some further time may be granted to him to produce such certificate. Stop. Land Council for the appellant also seeks for an adjournment. Place this matter in the week commencing from 17th March 2025.
Item 8.
This is application wife petitioner wife. Last date honorable directed to State Council after instruction regarding health condition of the wife.
Interim bail on the element of the wife.
My lord.
Yes, Mr. State Counsel.
But now he is saying that difficult.
IA number 363169 of 2020. There is an application for interim bail on the ground of ailment of the wife of the petitioner. Medical document has been annexed to the interim application. The London Council for the State on instruction, and I produced the written instruction received from IAC Chandrasekhar Police Station, Bhubaneswar UPD, wherein it is mentioned that the wife of the petitioner fell down in the bathroom floor and sustained injury on the wrist. And when the pain became severe, she underwent treatment in Kim's Hospital, Bhubaneswar, and the doctor advised to conduct MRI and other tests which could not be done. The father of the petitioner is aged about 90 years and bedridden, and the brother of the petitioner is a younger brother of the petitioner, is a partially mental disabled. The written instruction is taken on record. Considering the submission made by the Land Council for the respective parties, the averments taken in the interim application, the medical document annexed to the interim application, the written instruction received by the Land Council for the state, we are inclined to release the petitioner on interim bail period of 4 weeks from the date of release. While on interim bail, the petitioner shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of interim bail order. Yes, next.
3 months back.
Yes, next.
Item 9.
How you came to High Court to show an affidavit in this interim application? Hello? ଆପଣଙ୍କର ତ ଅଣ୍ଟା ଇଏ ହେଇଗଲା କଣ ଫ୍ରାକ୍ଚର ହେଇଗଲା କହୁଛନ୍ତି ହାଇକୋର୍ଟରେ କେମିତି ଆସିକିନି ଆଫିଡେଭିଟ କଲେ 7/12/2024
ସତ୍ୟ ଗାଁ ଆସିଥିଲେ ଗାଡିରେ ମୁଁ ଯାଇ ନିଜେ କରିକି ଆଣିଛି
କଣଟା
ଗାଡିରେ ଆସିଥିଲେ ମୁଁ କରିକି ଆଣିଛି ତା କଣ୍ଡିସନ ମୁଁ ନିଜେ ଦେଖିଛି
ନିଜେ ଦେଖିଥିଲେ
ମାଇଲ ଏଇଟା ସତ
ଆଫିଡେଭିଟ ହେଇଛି ଏଇଟା
ହଁ ଆଫିଡେଭିଟ ମୁଁ କରିକି ଆଣିଛି ନୋଟା ଦେଇଛି
ନୋଟାରୀ କଣ ଯାଇଥିଲା ତାଙ୍କ ଘରୁ
ନାଇଁ ନାଇଁ ଗାଡିରେ ଆସିଥିଲେ ମୁଁ ଆଣିଛି ଦସ୍ତଖତ କରିକି ମାନେ
ଗାଡିରେ କିଏ ଆସିଥିଲା
ପେସେଣ୍ଟ ନିଜେ ସାର୍
ପେସେଣ୍ଟ ନିଜେ ଆସିଥିଲା
ସାର୍
6 ତାରିଖ ଦିନ ଘଟଣା ସିଏ ପଡିଛି ଆପଣଙ୍କ ପାଖକୁ ପଳେଇ ଆଇଲା ଗାଡିରେ
ମୁଁ କହିଲି ମେଡିକାଲ ଟ୍ରିଟମେଣ୍ଟ ଏସିବିରେ ବେଲ୍ ମିଳିବ ସେ ଏସିବିରେ ପସିବଲ ନାହିଁ ଆପଣ ଦେଖନ୍ତୁ ମୁଁ ଯାଇ ତାଙ୍କ ଦସ୍ତଖତ ଆଣିକି କଲି ଆଉ ତାଙ୍କର କେହି ନାହାନ୍ତି ଲୋକ ଆଉ ଫାଦରର କଣ୍ଡିସନ ଭେରି ପାଥେଟିକ ଆଉ ଗୋଟେ ଭାଇ ତାଙ୍କର ପାଗଳ
That's all right, we have mentioned it.
My lord.
କୋଉଠି ଘର କୋଉଠି ଲୋକର
ଘର ମାଲର ତାଙ୍କର ଡିଷ୍ଟ୍ରିକ୍ଟ ହଉଛି ଅନଗୁଳ
ଦେଖ the IAC Bond Park Police Station shall keep a close watch on the activities of the petitioner while on interim bail. ହେଲା
ମେଡିକାଲ ରିପୋର୍ଟରେ ତାର ଷୋଳଶହ ବିହାର ଆଡ୍ରେସ ଦେଖଉଛି।
କୋଉଠି ରହୁଛି
ଷୋଳଶହ ବିହାର ଆଡ୍ରେସ ଏଠି ଦେଖଉଛି ମେଡିକାଲ ରିପୋର୍ଟ।
କୋଉଠି ରହୁଛନ୍ତି ଆପଣ?
ମାନେ ମୁଁ ଆଡ୍ରେସ ଟି ଦେଇଛି କୋଉଠି ଦେଇଛନ୍ତି?
ଆଉ
ଶୈଳେଶ ବିହାର PS ଚନ୍ଦ୍ରଶେଖରପୁର ଡିଷ୍ଟ୍ରିକ୍ଟ
ଏଇଟା ଚନ୍ଦ୍ରଶେଖରପୁର ତ? ଆଚ୍ଛା ସେ ଆଇଆଇସି ଚନ୍ଦ୍ରଶେଖରପୁର କରିବ ହେଲା।
ଷୋଳଶହ ବିହାରରେ କିଛି ନାହିଁ ପୋଲିସ ଷ୍ଟେସନ ନାହିଁ।
ସେ ଚନ୍ଦ୍ରଶେଖର
ଶୈଳେଶ ବିହାର ଟା ଯାଉଛି ଚନ୍ଦ୍ରଶେଖରପୁର। Free copy of the order. Yes.
Item 9.
File the application for interim bill for the treatment of our father and mother matter. This is my third time matter. Earlier I have already enlarged bill for 1 month and there are
ବର୍ତ୍ତମାନ କଣ ପାଇଁ ଇଏ କରୁଛନ୍ତି?
fathers and mothers treatment for 2 months my lord.
560 of 25.
My lord.
କଣ ହେଇଛି ବାପା ମା?
ବ୍ରେନ୍ ହ୍ୟାମରେଜ କରିଯାଇଛି। ବ୍ରେନ୍ ହ୍ୟାମରେଜ ଫାଦର ମଦର ମଧ୍ୟ
କଣ ଡକୁମେଣ୍ଟ କଣ ଅଛି?
ମେଡିକାଲ ଟ୍ରିଟମେଣ୍ଟ ଡକୁମେଣ୍ଟସ ଦେଇଛି ମାଇ ଲର୍ଡ under annex 1 and 2 series.
What is your instruction?
They have not solved the copy.
You have not solved the copy.
I will serve another.
Solve.
I will serve another. I have already served. I will serve another.
Oh, you also obtain instruction about their conduct because he was earlier released on interim bail. As he stated. IN number 560 of 2025. This is an application for bail, interim bail on the ground of element of the parents of the petitioner. Some medical documents have been annexed to the interim application. Let a copy of the interim application along with the medical evidence, medical documents be served on the land council for the state. Also, the copies of the deposition of the witnesses examined in the trial court. The land counsel for the petitioner submits that earlier the petitioner was granted interim bail. Twice in a criminal appeal. In this criminal appeal. While obtaining instruction on the interim application and authenticity of the medical documents annexed to the interim application, the land counsel for the state shall also obtain instruction about the conduct of the petitioner while on interim bail. Put up this matter in the week commencing. Who thana ro asibo? Who thana under emanku karo? ये डॉक्यूमेंट जोड़ा ଦେଇଛନ୍ତି मेडिकल डॉक्यूमेंट को थान को हॉस्पिटल लो
एम्स से ଦେଇଛି ଆଉ ତାପରେ ଫକୀରମୋହନ କଲେଜରେ ଦେଇଛି ଆଉ ତାପରେ ଡକ୍ଟର ଅଭିନୟ ପଣ୍ଡାଙ୍କର ମଧ୍ୟ ପର୍ସନାଲ ଦେଇଛି।
ଏବେ କାରବ
ମାନେ 2024 ରେ ଦେଇଛି ମାନେ
କାଇଁ ଆଉ ଦେଲେନି 2023 22 ର
ଆରମ୍ଭ ଦେଇଛି ବଟ
ରିସେଣ୍ଟ ମେडिକାଲ ଡକ୍ୟୁମେଣ୍ଟ କଣ ଅଛି?
25/4/2024 ପରେ ଆଉ ଦେଇନି। 25/4/2024 ପରେ ଆଉ ଦେଇନି।
ତ ଭଲ ଅଛନ୍ତି ଆଉ ବିଲ୍ କାଇଁ ଦିଅ ନିଆ ସୁନ ପ୍ରେଜେଣ୍ଟ ହେଲ୍ଥ କଣ୍ଡିସନ ଆଣନ୍ତୁ। यस
ମାନେ 18/2/2025 ମୁଁ କପିଟା ସର୍ଭିସ କରିଛି ମ୍ୟାଡମ। ଗଭର୍ଣ୍ଣମେଣ୍ଟ କୁ 18/2/2024 ରେ ମୁଁ କପି ସର୍ଭିସ କରିଛି। 25 ରେ ପୁରା 25 18/2/25
ସେତେବେଳୁ ସାର୍ ନଥିଲେ ପ୍ୟାନେଲରେ ଆସି ନଥିଲେ।
18/2/25
ସେଥିପାଇଁ ସେ ଜାଣିଲେ।
ଆଇ ଅଲରେଡି ସାର୍
ଆଉ ଗୋଟେ କରିବେନି ସର୍ଟ
ଆଜ୍ଞା ଦେଇଦେବି
ୱାହାଲା ପେ
ହଁ ଦେଇଦେବି ଆଜି ଦେଇଦେବି।
10th of March 2025 yes
Item 10.
Item on behalf of Mr. Salvesor Sami, may I please look. Last of the defect already removed matter.
Defect you have removed.
Yes, ma'am.
आपको सर्विस कले अपील मेमो आ ये अपील मेमो आ इंटरिम एप्लीकेशन अच्छा आपण भी रिसीव कर देले इंटरिम एप्लीकेशन कॉपी उडा तो डिफेक्ट कोन देखौ जंती एसा
नहीं सर भूल
Defect already removed.
5 रे डिफेक्ट नंबर 5 as per SR is removed. डिफेक्ट नंबर 7 टा कला कोड
7 टा होची कोड नोट सेटा को इग्नोर करियो बट अच्छा देयर इज अ डिले ऑफ 7 days in filing the criminal appeal yes sir
सर एमती को सर डिफेक्ट नंबर 5 as per SR is removed. तापर पुणी अच्छे केमती लिखो 4 रे पुणी 3 रे 10 रे केमती डिफेक्ट नंबर एती as per SR बात में
state copy 5 bit out state
copies of 3 areas have been supplied to land council for the offender.
से जो ऐसा ये था हमारा एसआर टा को देखिले एसआर को क्लिक कले जणा पड़छि 7 दिन ଭିତରେ ଅଛି फुट साइड एसआर क्लिक এই পোরশনটা এটা শেয়ার করব ওকে করব আটা করব করব 7 days के लिए state में 5 को बड़ी डील लगाएगा it's a life condition
Yes, ma'am. Rolling by 24.
IN number 1653 of 2023. This is an application for condonation of delay. The stamp reporter has pointed out that there is 7 days delay in filing the criminal appeal since the appellant has been sentenced to imprisonment for life. After hearing the land counsel for the parties, we are inclined to condone the delay. Accordingly, delay is condoned. IA disposed of admit call for the trial court report, interim applications for bail and stay relation of time to be considered after receipt of the trial court report. Yes.
376-2M.
Huh?
376-2M.
Acha. The X 376-2
N and POXO.
POXO and then the extra copy of the appeal.
And 14 years, 1 month.
And in the case,
Minor computer. I often
this person.
14 years, 15 days.
Earlier your bail application was rejected?
No, no, but
first time was.
I filed an interim application and it was not placed. Therefore, this bail. By the time the interim application was taken, the purpose for which it was filed was materialized.
এটা হচ্ছে যে পোস্ট পেয়ে এটা হচ্ছে সেটা হচ্ছে আপনার ইউটিপি লাগে condition figure on the one so the following is a missing machine there is seven charges from purchase and so the so the violation of 14 years
26/1/2011.
So what is the prosecution case?
Prosecution case not because of previous dispute. This is also a HTC. It is alleged on the relevant because of some dispute when you are taking fees. The benefits appellant along with the two others who have been granted bail in the meantime.
they went there and they told that particular this is the present petitioner by means of a country-made got fired.
What about the criminal antecedent?
Well, the apparently involved 8 cases, madam.
File comprehensive affidavit. Give the numbers to
Well,
Mr. Chan. Land counsel for the state has produced the custody certificate of the appellant from the who jail
Sambalpur, yes.
From the senior superintendent circle jail Sambalpur, which is taken on record. No. Let the land counsel for the state land counsel for the state submits that he has received instruction that the petitioner has got 8 criminal antecedents. Land counsel for number let the land counsel for the appellant obtain instruction relating to the status of those cases and file a comprehensive affidavit serving a copy on the land counsel for the state. Put up this matter in the week commencing from 17th March 2020.
Item 12.
May I please? The appellant convicted under section 376(1) of IPC for 7 years, madam, and for section 32B of section convicted under section life, madam. And for 376(1), madam, the appellant convicted for 10 years, madam. 7 years. And for 32B, madam, SC and ST Act, he has been convicted for life. Madam.
Notice has been issued?
Yes, madam.
What about the notice? Pre-existing notice is required to be served on the informant. So what happened? The direction was issued also, an order was passed to that effect on 27/8/2020 that it has to be sent to the IIC Jharigam police station for its service on the. What happened? Hey, no. Service AG. The land counsel for the state has produced written instruction received from IIC Jharigam police station dated 23/11/2024 relating to the service of notice on the victim. The written instruction is taken on record. Non appears for the victim. So, have you received the deposition copies?
No, I have already filed. Physical file.
Who did you? File 9. Next week, the land counsel for the state submits, land counsel for the appellant submits that he has sought the deposition copies of all the witnesses examined in the trial court in the AG office. However, the land counsel for the state submits that the deposition copies are not available on record and the matter may be taken up a week after court. Put up this matter in the week commencing from 10th March 2025.
Item 13.
May I please, my lord? May I please, my lord?
Yes.
present appeal, I have filed a bail petition. Wait, just a minute. You are supposed to receive produce the cost certificate. Have you brought it? Yes. How many years?
What's the
9 years, 6 months. And what about the criminal antecedent?
that's ignorant?
No, you said that you have received the criminal antecedent. Last time we passed the order, the 19 to 25,
Nothing at all.
nothing adverse. So, is it your first application, Learning Council? My lord, this is my first application. First bill application. So, you are the appellant has been convicted under which offense? He has been convicted under section 302 and sentenced for life imprisonment. At the same time, he was also acquitted from charge under section 341-32 IPC. Even the other co-accused are also acquitted on the same set of evidence. No, so main offense under which you are found guilty is 302.
Accident.
All right. What is the prosecution case? My lord. Paragraph number 2. My lord. The prosecution case is that the appellant was working as a security guard in a construction company. And please to the paragraph number 2 of the judgment. My lord. And please place it. Manglu Rajmangal Meher, deceased, and the accused Abhishek Kanti, the present appellant, was appointed as a security guard in a construction company. Yes. Accused Biju, that is the present appellant, was suspected for committing theft of some article of that company. The deceased, along with his friend, proceeded to the said construction company to ascertain the veracity of such theft. Accused Biju Abhishek Kanti was inquired for said theft. Deceased Rajmangal Meher intervened and the accused Abhishek Kanti dealt a knife blow to Rajmangal Meher and Rajmangal Meher raised Allah Morigali. In fact, Your Honor, the present Mr. Counsel, deceased wants to intervene. Accused Biju dealt a knife blow to so and so, and Raju raised Holla, Morigali, others. Okay. So it's you have given a knife blow to deceased. So that is the prosecution case. So yes, how many eyewitnesses are there? Actually, 15 witnesses are examined in this case. No, eyewitnesses, how many? Eyewitnesses, 3. Prosecution relied upon the more particularly 3 eyewitnesses. Who are those 3 eyewitnesses? They are the PW4. PW4. And PW7. Yes. And PW8. And who is the doctor who conducted PM? Doctor is PW? 10. Dr. 10. Seema Parai. All right. So he noticed one penetrating wound present over the right iliac fossa
through which a drainage strip was given. On removal of the so-and-so, it was noticed that the wound was having sharp margin. बाकी दिटा हला abrasions. Toe गोटे foot रे गोटे ଆଉ ଗୋଟେ abrasion ରହୁଛି left foot ରେ right leg ରେ internal injury ହଉଛି beneath external injury number 1 muscle peritoneum were cleanly cut. Direction of the injury was so and so obliquely upward. So external injury was antemortem in nature. So and so have been caused by sharp cutting. Fatal cause of death was shock and hemorrhage as a result of the external injury number 1. All right. So what is the evidence of these eyewitnesses? Let us come to one eyewitnesses. PW4, you said one eyewitness.
PW4.
Yeah. What he has stated? Incident took place on 10/6/2025, 2015, sorry. Date of occurrence. So when he expired, the deceased?
On the very same day, he initially received treatment at district headquarters hospital. Subsequently, he was shifted to Bhimsar and where he succumbed to his injury.
Deceased came to know that accused Biju has committed theft of the pump. When the deceased asked Biju about the theft, accused Biju stabbed so and so. Oju has presented the spot and so okay. No, what is your submission, Land Council?
My lord, I would like to take your honor to the para 9 of the judgment.
What is that?
Para 9.
Yes.
Honorable trial court held that the learned counsel for the accused Dharam Korali, Oji Avinash Tanti and Biju Abhishek Tanti argued that the evidence of PW10 reveals that as per the police requisition, the width of the knife was 8 cm. And during cross-examination, he admitted that external injury 1 along with its corresponding internal injury are not possible by a knife of 8 cm width. So the case of the prosecution that due to step by the seized knife of the deceased died is not established by evidence of PW10. Besides, my lord, it has not prosecuted.
That is the submission.
Yes.
But your that suggestion was denied by PW10. The doctor has denied this suggestion that it is not possible to answer. Now, fact remains that 3 eyewitnesses are there, and their version is that you stabbed the deceased, and the deceased was having an injury on the abdomen portion, and which was missed by the doctor PW10, and the said injury has also been opined to be fatal in ordinary course of nature to cause death. This is the evidence of the prosecution. So,
but my lord, prosecution has not explained how all such injuries, there are 6 injuries.
so the other injuries are possible by fall, these abrasions, etc. Somebody may be struggling after falling down on the ground, and those injuries are possible, abrasion. It is not that once he stabbed, he will remain static as such. He will not roll here and there, and he might be also shifted during course of that. Also, this possible, these abrasions are possible. These are main injury is that penetrating wound which was noticed on the abdomen portion.
Injury number 6 is also important, Your Honor. One wound having present over the MD line of the hypogastric area. There are another injuries which was stitched at the time of PM report. And doctor who treated has not been examined in this case.
No, this is the PM doctor because the cause of death was due to injury number 1 that has been attributed to injury number 1. The injury number 1, someone has tried to give stitch to that wound to stop the drainage of the blood. That is how that 18 stitches were found on that hypogastric area. But all the same, the evidence is that you have given that blow on the knife on the এটা লেখিটি কিছু এই যে criminal antigen produce করে কিছু লেখি না দিয়ে লেখুন
They are not to solve the deposition purpose.
IN number 2179 of 2024. This is an application for bail. Heard Mr. Surendra Mahanti Lancil appearing through virtual High Court Hon'Ble and Mr. Nayak, Land Additional Government Advocate. The Land Council for the state has produced the custody certificate of the petitioner submitted by the Senior Superintendent Circle Jail Sambalpur, which indicates that the petitioner is in custody for more than 9 years. The certificate is taken on record. Land Council for the state has also produced the written instruction received from the IIC Dhanupalli Police Station dated 22/9/2024, which indicates that there is no criminal antecedent against the petitioner. The written instruction is taken on record. Mr. Mahanti Land Council submits that the occurrence in question took place on 10/6/2015, and as per the eyewitnesses account of PW4, PW7 and PW8, when an allegation of theft of some articles of a company in which of a construction company in which the petitioner was the security guard was made, and the deceased and his friends came to the construction company and challenged the appellant over such issue. It is stated that the petitioner gave a knife blow on the abdomen of the deceased, as a result of which He was shifted to the hospital and ultimately he died on the date of occurrence. The Land Council submits that in view of the factual scenario, it may not be a case under Section 302 IPC, and there are good chances of success in the appeal, and balance of convenience is in favor of the petitioner, and therefore the bail application may be favorably considered. And counsel for the state oppose the prayer for bail. Peruse the evidence of the eyewitnesses PW 4, 7, and 8. So also the evidence of PW 10 was noticed a penetrating wound over right iliac fossa and opined that the cause of death was due to shock and hemorrhage as a result of the external injury number 1 along with its corresponding internal injury. Considering the submission made by the Land Council for the respective parties, in view of the direct evidence of 3 eyewitnesses coupled with the medical evidence, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody, absence of any criminal antecedent, and absence of any chance of early hearing of the criminal appeal in the near future, since it is a criminal appeal of the year 2024, we are inclined to release the petitioner on interim bail for a period of 3 months. While on interim bail, the petitioner shall not indulge in any criminal activities. A violation of any terms and conditions shall entail cancellation of bail. The matter be listed 3 months for a particular. The Land Council for the appellant shall produce the surrender certificate of the appellant. Yes.